Good morning, everyone, and welcome to this seminar co-organized by ICC Italia and UNIDROIT, here presented by the Deputy Secretary General, my colleague and friend. I can share this, Anna Veneziano. First of all, I wish to thank UNIDROIT again for hosting on such beautiful premises both today's event and the ICC Commission on Commercial Law and Practice meeting chaired by Professor Erdem, held yesterday afternoon. As we all know, force majeure and hardship have become increasingly urgent and relevant for businesses in the latest years after the outbreak of the COVID-19 pandemic and then the restrictive measures adopted towards Russia. Many companies were unprepared for such events, preventing them from performing their contractual obligations, determining severe losses, and disrupting the supply chain. The provision of well-written force majeure and hardship clauses can make a difference. And substantial discrepancies are still present in national laws. There is a different approach of civil and common law countries to the pacta sunt servanda and rebus sic stantibus principles, to contract immodifiability and non-performance excusable by the occurrence of qualified contingencies. In civil law, authors in case law have preceded legislative reforms. Before the 2016 reform in France, new solutions were based on the imprévision theory. In Germany, before the 2001 reform, innovative developments were grounded on assumption, we call it presupposizione, economic impossibility, and loss of contractual roots theories. As for remedies, in both countries, and unlike Italy, alongside termination, there has been an opening towards renegotiation and the power of a court to adapt the contract as a contract maintenance technique. That follows the lex mercatoria solutions expressed by instruments such as the UNIDROIT principles and the ICC standard clauses, which will be discussed in more detail today. In common law, the absolute contract principle is more firmly established, and the frustration cases are interpreted narrowly. Moreover, remedies available in case of excusable non-performance are only damages and termination, not renegotiation and adaptation of the contract by the court. The trade practice we talk about today blurs these differences. The 2020 ICC force majeure and the hardship clauses and the UNIDROIT principles can provide a useful instrument for contracting parties in their negotiations, mostly for their flexibility and their possible adjustments to be adapted to different situations, such as those we are facing these days with the increase of the energy product price. We will hear the direct experience of companies facing these problems, and we will try to give many other companies a few more tools to go and meet international trade more prepared. To end, let me thank the chair of the conference, Professor Fabio Bortolotti, for promoting this event and gathering such a notable panel of international experts. Thank you all for joining us today, both in presence and remote. Professor Erdem, the floor is yours.
Thank you, ladies and gentlemen, dear friends and dear colleagues. I'm very happy to be again in Rome in this beautiful house. We had several conferences here with CLP Commission. So the idea to have a force majeure conference, as already said, was Fabio's idea. When ICC accepted the force majeure clause 2020, late in 2019, Fabio proposes to have a conference for the launch of the force majeure clause and hardship clause. And he proposed to do that with UNIDROIT and ICC Italy. We were very excited what COVID happened. And then we have to wait until today to see that this conference happening. So I'm very glad to be with you today for this conference. And thanks again to UNIDROIT, thanks again to ICC Italy for hosting us and for co-organizing this conference. I hope that we will all enjoy. Thank you.
I will try to be as short as possible because we are a bit late. First of all, thanks to UNIDROIT for hosting us in this marvelous location. I am always happy when I am here. I always think how many books I should look at here, but I don't have the time and I am too old probably to continue searching. No, never. But anyhow, it's a marvelous place and marvelous people, and so we are very happy to be here. And I must also say, I am happy to present our work here because UNIDROIT plays an essential role in developing appropriate rules for international contracts, commercial contracts. I think that we have given much importance in the ICC, in our model contracts, to the UNIDROIT principles, which we think can be a very useful alternative to national laws. And so we are supporting this. We are not supporting lex mercatoria in general ways, general principles of law. We think that that doesn't help very much people. But lex mercatoria and the UNIDROIT principles together can be a very, very clever and interesting solution that can replace English law, Swiss law, and so on, which are more complicated. So I am very, very much in favor. And that's all. I would now give the floor to Anna Veneziano, who will tell us the role of, about the role of UNIDROIT in this context of force majeure and hardship.
Thank you. Thank you very much, Fabio. Yes, so this is the first slide, and I will, perhaps we can immediately move to the second one. I can do it myself, which is fine. So once again, greetings to everyone. As you see from the title, which is this one, and the shorter length of the presentation, its aim is just to offer an introduction to the topic of the conference, which is actually the ICC clauses and their application, referring in particular to the approach of the UNIDROIT principles, which was already mentioned, to force majeure and more generally to supervening events. And indeed, we thought it was important to do so for a number of reasons. First of all, because as was recalled, the ICC clauses, and particularly the force majeure clause at the time, were an important source of inspiration for the UNIDROIT principles themselves when they were first drafted and published in '94. And also because in their turn, the principles have had an influence, among others, on the most recent reform of the ICC clauses. And another reason to focus on the UNIDROIT principles, even if only briefly, is that, as you may be aware, the UNIDROIT Secretariat released in 2020 a note entitled UNIDROIT Principles and COVID-19 Health Crisis, which you can find on the internet, if you wish, and which sought to offer guidance as to how the UNIDROIT principles, particularly, though not exclusively, the provision of force majeure and hardship, could help parties, adjudicators, or legislators solve the main contractual disruptions which were caused by the pandemic and by the measures adopted as a consequence thereof. And we were actually induced to release this note because we became aware that in the debate at domestic as well as international level on the most appropriate legal responses to this crisis, the UNIDROIT principles were often cited as a sort of a reasonable and balanced solution, which of course can be discussed more generally for supervening events. Now, in this very brief presentation, I would like to try to substantiate this claim and respond to the question, why are the rules on supervening events in the principle interesting for commercial practice? And the main advantage, I think, is that they offer, as you know, non-binding and default rules, which on the one hand take party autonomy very seriously into account. And I will come back to this because it's very important also in this context and for the relationship with the ICC clauses. And on the other hand, they consider the need to ensure that the contract is binding. So the fundamental rule is that the contract is binding, but they try to offer sufficiently flexible risk-sharing alternatives for the parties, which might even be invoked after the event. And this is particularly true for the rules on hardship, as we will see. So I would like to start with the provision of force majeure in the UNIDROIT principle 717. I'm, of course, not going to lecture you on this. You are probably much more aware of that I could ever be of the content of this provision. But what I would like to do is just to highlight a few elements that might be interesting for the ICC clauses and for the debate. First of all, as you know, as opposed to the more traditional approach that we found or find in some domestic legal systems, the principles followed the model of the CSG and therefore did not mention strict impossibility or other terms referring to that, like frustration, but they use the more general concept of impediment, which allows, of course, a wider application, but the impediment still has to meet the strict requirements that are set out in the provision. And I will not focus on the requirements, just to say that in the note on COVID-19 that was released, we tried to focus on the requirements of reasonable foreseeability and avoidability, and consider what would have been the factual circumstances to be taken into account to evaluate whether there was or there is force majeure, pointing to the complexity of this analysis. So the relevance of the time of conclusion of the contract, the place of business of the parties, type of contract or obligation, and the type of containment measures adopted. I would like now to highlight only other two further elements in this force majeure clause. First of all, the express provision of the consequences of a temporary impediment, and this is important for the discussion on the clauses. Secondly, the provision of a notice on the non-performing parties, which is of course important for commercial practice and for clarity and predictability, and sanctions for not complying. And then the effects, and this is what actually distinguishes the force majeure in the principles from the hardship. The party is excused from non-performance and from liability in damages, while, and this is expressly stated in the principles, the other party can still exercise other remedies if their conditions are met, of course, like termination, suspension of performance, or can claim damages. But I will immediately move to the hardship provisions of the principles. You see the three of them on the screen. Of course, they're even more innovative and especially useful from a practical perspective as a solution to the type of disruptions that are likely to arise not only in the context of the pandemic, but also in a post-pandemic scenario. And it is important, first of all, to underline what I said before, Article 6.2.1. The binding nature of the contract is reaffirmed. So it is an exceptional situation, but we will see, of course, that parties can then decline this risk-sharing alternative as they prefer in their contract. And we also see what are the requisites in order for, and the definition of what is hardship, but I will not focus on that because what I think are the most interesting aspects in this context are the effects of hardship. So the provision, as was already mentioned by Barbara, take into account the interest of the parties that might wish to preserve the value of the existing contract, while at the same time finding a way to address the supervening imbalance created by the change of circumstances. And as we see, the first consequence of hardship is that the disadvantaged party is entitled to request renegotiations. And we have seen, and Barbara has already mentioned it, that this is a solution preconized even in systems which then were reformed and modified initially based on general principles such as solidarity or even good faith. It is certainly a most flexible way to encourage parties to find the appropriate answers to the new situation. It's a flexibility that facilitates the reasonable solution of controversies, which when you have many, like in situations of crisis, is good because it avoids a high number of lawsuits, at least it could be one consequence. And it also provides a good default rule for mediators or arbitrators trying to reach a reasonable solution. And I will come back to this point. If parties do not find an agreement within a reasonable time, each of the parties can request judicial intervention. And the judge has a number of alternatives at disposal. It can keep the status quo. It can terminate the contract by defining the effects of termination ad hoc, because it's not termination for non-performance. And it can modify the contract to restore the original equilibrium, adapt the contract. So sometimes this intervention of the judge has been criticized of not being always the right solution for international commercial contracts. There is an element of discretion which is left in the hands of the adjudicators in this case. Of course, it might be different if there is an arbitral decision. But I would like to underline, and I'm really moving to the close of this presentation, I would like to highlight a couple of points that might be interesting in this debate. First of all, we have seen that allowing a margin of discretion to adjudicators has actually been positive and not negative in times of crisis. Secondly, the very existence of the provision that would allow a judge to intervene and adapt the contract provides an incentive to the parties to reach an agreement. And it might be a very good tool in the hands of a mediator or an arbitrator to find this agreement. The second point I would like to underline is the one I have mentioned at the beginning, the relevance of party autonomy in the context of the UNIDROIT principles. The principles are a non-binding set of principles and rules. They are a tool, as Fabio has reminded us, a versatile tool in the hands of parties, adjudicators, mediators, and so they should be used if and when they are useful. And they contain default provisions for the most part, which are therefore perfectly compatible with the ICC clauses. And parties may decide, therefore, to modify some of the elements of the discipline. For example, excluding certain remedies depending on the type of contract and the relationship between the parties. But this is something that should be, of course, considered by the parties and well-reasoned. And maybe even more importantly, they can further detail the conditions and consequences. For example, this can be done for the force majeure, for example, to introduce additional elements of predictability, but also for hardship. For example, they may provide a framework for the renegotiations, or on how to proceed with the adaptation of the contract to the new circumstances, so to give some element of additional predictability to the general rule that there might be an adaptation of the contract. And my very last point concerns the principles as a whole. Just to remind that the rules on force majeure and hardship of the principles are part, of course, of a more general normative framework that facilitates the interpretation and application of these rules. And among others, we refer to the provision on good faith in international trade, the duty of cooperation, the rules of mitigation of damages. And just to give you an example, in the note that we have released, we underline that the obligee cannot just passively sit back. Depending on the circumstances, may have to take reasonable steps to reduce the harm, which otherwise would not be compensated. And here the reference is to Article 748 of the UNIDROIT principles. And thus, if the obligee has knowledge from other sources of the obligor's inability to perform, it could reasonably have been expected to take measures to reduce the harm, and therefore it might not receive full compensation. But I will stop here because I'm sure you are eager to hear my colleagues and friends who will talk about the ICC clauses. And thank you very much for your kind attention.
Thank you very much. It was very interesting. I am a great supporter of the UNIDROIT principles. I think it's easier to draft a contract to work under the UNIDROIT principle than under any national law, because national laws on contracts are the fruit of long discussions and complications, and I think it's really a good idea, and we are supporting very much this. Of course, on the hardship clauses, we have some different ideas, but we have tried to find a solution in our model, which is please choose about the possibility of adaptation or not adaptation, because I think that there are situations where this is recommendable and there are others where it's not. So we have done also a great effort in this sense. And so I will now give the floor to Ercüment Erdem, who is a counsel in Turkey and who is the chair of the CLP Commission, and who has given a great contribution to the work we have made in drafting the model contract. So I think his contribution has been really essential. So he can tell us, give us an overview about the problems, the solutions, and so on. Thank you. Please.
Thank you, Fabio. Can I have the... Yes, thank you. Ladies and gentlemen, thank you and welcome again. So the topic that I would like to deal with you is the new ICC Force Majeure and Hardship Clause 2020. So for the first time, ICC, perhaps I have to start what we are doing in ICC CLP Commission, Commercial Law and Practice Commission. What we are doing, it's very basic. We are producing soft law product. Model contracts, Incoterms, force majeure clauses, just to help international trade community, to facilitate their task, to facilitate the trade, to help them through reliable, balanced contract model clauses or guidelines or position papers. So ICC force majeure clause is one of the product of the ICC CLP Commission. It was for the first time published in 1985, and this edition was based on the CISG model exoneration clauses. Then a revision was made on 2003, and it was very well accepted and applied by the users. So why there was a need of the revision of the ICC 2003? I don't know whether you have already seen the ICC 2003 edition. It's a very small booklet with a blue cover, but the users tell to the national committees that we have some difficulties to incorporate it in the contract. So we thought it may be useful to have a short form or a short clause directly to be inserted in the contract. And we started the work just to draft a short form. But you know the revision. When you start to do something, then it develops, evolves, and it continues. We say, okay, but this short form, perhaps we have to revise, we have to see the totality of the clause, and then we enlarge the revision process. So how we made this revision? We set up a working group under the chair of Fabio with few academicians and practitioners. And when we start the revision process, we see that there are something to do because the clause, some clauses can be found complicated. Some other are not reflecting really the practice, and there were new trends, especially for the hardship that I will come back in a few seconds. But what we try to do is just to keep the essence, the skeleton of the 2003, the main principle. So the elements of the impediments, exoneration, everything has been kept. So I don't want to say that we have done only some formatting or stylistic revision. This is not the case, but the main principle are kept. And what is new, what is the trend in comparative law is reflected. Let me tell you the main characteristic of the new force majeure clause. As I said earlier, the main body is kept, but we introduced a definition of force majeure, what is a force majeure, and affected party. By the way, you can reach to the clause, force majeure clause and hardship clause through online in ICC website. This is a free publication of ICC, which is not very often, but this is the case for force majeure clause. And there was a very, very good introductory note drafted by Fabio, which explained how it works in reality, what is behind the black and white letters of the rules. We have added some paragraphs, headings, just to ease, to follow up the rules and to better understanding. We put explanatory notes, and initially we put in boxes, but then for drafting purposes, ICC changed to black letters, but at the end you can distinguish from the body of the text and the explanation. There is no difference between 2003 and the new clause with respect of the establishing the condition of the force majeure. We are in line with CISG, we are in line with PECL, and we are in line with UNIDROIT principle. It is amazing that UNIDROIT is saying we were inspired by the ICC force majeure clause, and we are saying that we are inspired by UNIDROIT principle. So, presumed force majeure event. As you know, the clause provides three conditions. And these three conditions have to be fulfilled. So, what is the purpose of this presumed force majeure events? These clauses are addressed to the SMEs mainly, or to small, medium-sized enterprises who does not legal counsel or in-house counsel, or who are not used to use even counsels. So we try to help them by providing some listed events, because if any event is listed, it is presumed that the condition A and B is fulfilled. So this is a favor for the users, just to check the events, whether they are included on the list or not. So the party who rely on that event does not need to prove that the conditions of being beyond the relevance party control and reasonably unforeseeable, these two conditions are met. What we have discussed in the working group, whether we have to keep this list, whether it makes sense to keep this list. After lengthy discussion, we decided to keep the list, but shorten and change a little bit, because some of the items are not reflecting the reality. Some of them, it's not easy to understand. It creates some confusion. And throughout the recent development, the sections, the embargoes, and so on, we put new ones. We edit new ones. I would like to emphasize that list is not an exhaustive list. You can add, you can take out whatever you want. Because at the end of the day, this force majeure clause and hardship clause do not apply themselves. It's an instrument that you have to incorporate in your contract, or you have to refer. By then, it becomes your contractual body, and you may use it. So under the freedom of contract principles, you can add whatever you want. You can take it whatever you want. How we work on this list? We review the published court decision on force majeure, review the published arbitration clauses. We take consultation from NCs, national committees, and we end up with the list that you have seen. In the current list, there are some items that we didn't list again, like armed conflicts, serious threat of the same, civil accommodation or disorder, mob violence or civil disobedience, curfew restriction, compulsory acquisition. So we discussed in the working group, and some of them we didn't understand either. And we asked to the user whether it makes sense for you to keep them. Nobody used them. What is funny, we discussed a lot whether we have to keep pandemic and epidemic. We discussed because since thousands of years we do not have any pandemic, but we see perhaps this is something important, we have to keep it. And what happened? The COVID-19, and there is a full recourse to ICC force majeure clause. The new events are currency and trade restriction and embargoes and sanction. We simplify some events like plague, epidemic, natural disaster, or extreme natural events, but you are always free to add or to delete other events. Notification requirement. This is something new. We added an explicit paragraph. So a force majeure event happened. Does the other party knows what happened in the other part of the world? Certainly not, in spite of the news and everything. So you have to notify your counterparty, and you have to say, I have an event of force majeure. I declare the force majeure event. Why the notification is important, I will come back in a few seconds, because we have provided a time frame after which you may recourse to some legal rights based on the events of force majeure. The consequences remain the same with a few modifications. It's very clear that the non-invoking party is entitled to suspend the performance of its obligation from the date of the notice. So for the civil lawyer, it's the well-known principles of exceptional nondimilati contractors. This is not new. But this is what is provided in many of the national laws, in Turkish law, in Swiss Code of Obligation, in French law, in BGB, in German law, and in UNIDROIT principles. So if the force majeure event it's continuing for a certain period, then there's no need for the party to be bound by the contract. They may declare the contract terminated. In the latest revision in 2003, there was now a time frame, and it created confusion because what is a reasonable time? 90 days, 30 days, 1 year, 2 years? So after lengthy discussion, we provide 120 days. Again, this 120 days is not compulsory. You can change, you can make 90 days, you can make 180 days, whatever you want. But the default position is 120 days. So 4 months seems to us and the national committees reasonable. We had different opinions in the VG, in the working group, but finally we find a compromise on 120 days. Now, some words on the new hardship clause. In the new hardship clause, fundamental changes have been made. The main characteristic of the new hardship clause are the following. We provide intervention of the judge or arbitrator. In 2003 clause, the only option was the termination. However, in civil law countries, in most of them, now the new norm is the adaptation of the contract. Why? Because termination should be the last resort. To the extent possible, we have to keep the contract alive. How are we going to keep the contract alive? By adapting to the new circumstances, by re-establishing the balance between the parties. So there was some fear, and it's already expressed by my esteemed colleague, Anna, that the judges or the arbitrators were not very well positioned to adapt the contract. They don't know the balance between the parties. But at the end, someone should intervene to create this balance. So what we have done, we have provided to the party 2 additional options. Termination, recourse to an arbitrator or to a judge to ask for adaptation of the contract. So the favor contractors to keep the contract alive is maintained. Option A, the same as previous edition in 2003, you can terminate the contract. Option B, you may invoke the clause and you may ask the judge or arbitrator to adapt the contract or declare its termination. So you go to judge or arbitrator, you ask 2 things, adaptation or termination. Option C is a modified version of the 2003 and the new option of option 3A. So you may ask to the judge or arbitrator to terminate the contract. It seems a little bit strange because one party has already the power to terminate itself, declare the contract terminated itself. So why we have to go to the judge? Because when a party declares the contract terminated itself, it creates, in most of the time, problems. Whether this termination is justified, whether there is an event of force majeure, whether you have waited for 120 days, and so on. But when you go to the judge or to an arbitrator for him or her to declare the contract, someone external will check whether the condition of termination are fulfilled. And if it is the case, then the termination will happen, which, in our opinion, may prevent further discussion and further disputes. This is why we have this option C. So, conclusion, we have made the most significant changes to the FM clause, the force majeure clause and the hardship clause, simplification of the presumed event, separate paragraph on notice requirement, suspension of the obligation performance, and fixing a time period of 120 days. On the hardship, the most relevant change is the adaptation of the contract. So we have now a really short form of the hardship and force majeure clause, but this is a short form of the long. So basically, this is the same thing. This is the same wording, but in a shorter version. So the new clauses accepted by the ICC late in 2019 and entered just before the COVID in force. However, please keep in mind that 2003 version is still alive. So the new one was not abrogated, the old one. You may choose whatever you want, provided that you refer to the correct version. Thank you, Mr. Chairman.
Thank you very much. I think it was really interesting. I remember you have really contributed very, very much. We had sometimes difficult discussions because he defends his idea very, very well, and that's important, I think, very positive. I would add a last thing, and then I hope that I get my slides in the meantime. The previous model clause was written by Charles de Battista, who is an English lawyer. He is from Malta, and the language was a bit too good to be understood by everybody. So, no, it was really too perfect English, and sometimes we must use a language that is a bit simpler. So another important thing is that we have tried to simplify the language to make it easily understandable to people who know English but who are not English. And I think this also has been an important point. Now, we are, yes, I have 20 minutes. I will do my best to be short. Where should I? Here. So I will speak about arbitration and force majeure. I think that arbitration is very important in this field because the force majeure problems are complicated. They imply that you understand really what the needs of the parties are, how the real actual situation is, and this is done better by experienced arbitrators than by judges. In many cases, not always, there are judges who understand perfectly business, but most of them not. So I think that's important. The big problem at the beginning is I have tried to make a review of arbitral cases, and is that there is a great variety of applicable rules in the cases we see. Sometimes it's a domestic law that applies to force majeure, or if it exists. Then it may be the CISG, Vienna States Convention. General principles of law, lex mercatoria, and the UNIDROIT principles, for example, and very often a force majeure clause agreed between the parties. This is, I think, the most common solution. And here too, of course, every force majeure clause is different. So you would say, but what sense makes it to speak about trends in arbitration if the arbitrators deal with things that are so different between them, with situations that are not comparable? This is not true, because I think that actually the problems behind are the same, and so it's interesting to look at it. But first I would say a few words about the relation between the force majeure clause and the applicable law. That's a problem. Is if the force majeure clause deviates from the rules on force majeure of the governing law, what happens? the force majeure clause, if they are not mandatory, the force majeure clause will clearly prevail. But sometimes, not really the domestic law, but some general principles will in any case prevail when the clause is a clause that doesn't work. So I will take a case which is interesting. This Gujarat Petroleum Corporation. This is a case of a company that was doing works in Yemen, and then they had problems. And the force majeure clause, you see it here, force majeure within the meaning of this agreement shall be any order, regulation, or direction of the government. This is a bad clause, of course. Or with respect to by a contractor, insurrection, riot, war, strike, etc., etc. There is no mention of unforeseeability and impossibility. And so the Yemen party, which wanted its own law to be applied, said, but it's impossible, since there is no, since we must apply Yemeni law, which provides unforeseeability and impossibility. How can you have a clause where there is not the requirement of impossibility? What have said the arbitrators? The arbitrators have said that actually the rules will prevail. The clause will prevail. But as regards the unforeseeability, the impact of disturbances and security attacks, which had drastically increased, made it impossible to continue performance. According to the arbitrators, the significant increase in risk would in any case have been unforeseeable and would therefore have justified force majeure even if the requirement in question had been deemed applicable. So they make they put the requirement actually through another way in the contract. The same for the impossibility. The arbitrators reintroduced, when interpreting the clause, such apparently missing requirement, arguing that, although not expressly mentioned, it must have been implied by the parties, since the force majeure clause required that the non-performance should have been caused by circumstances of force majeure. So we can go on. Another interesting case is this National Oil Corporation. Libya, it's a famous case. Here too, there was even not the impossibility, if I remember. And they wanted, the Libyan party wanted to apply Libyan law. Here, there was not the impossibility, and the arbitrators said it would be unjustified in the absence of any specific provisions to such effect to construe such article as revealing the intent of the parties to waive an essential rule of the Libyan common law, according to which force majeure is only established when the event invoked by the defaulting party created an impossibility to perform. So they don't apply directly Libyan law, but they say it makes no sense that this requirement is not, so they correct a clause that is not well drafted in a certain sense. But this is the trend, no? A trend whereby the arbitrators tend to recognize the freedom of contract of the parties and the freedom to choose what requirements are to be put, but at the same time, they don't accept that the basic requirements which are recognized wherever in the world are not respected. So they make this, but they have this common approach at the end. The basic conditions, okay, we know unforeseeable, irresistible, beyond the control of the parties. I would add that a very important requirement currently recognized in arbitral case law is the non-assumption of risk. The requirement that the impediment must not fall within the sphere of risk of the party suffering the event. This is very important because people who do not know about, have not studied force majeure and all these matters, do not imagine this. So I will come back later to this, but this is very important because what is not under your control, what is under your control, what is something that you are managing, cannot be considered force majeure, an event that you should have controlled. We will come back to this. First requirement, unforeseeability. Well, it's an easy way also to solve problems for the arbitrators. If you can decide that it was foreseeable, then you need not go into more details. So we have here one case, revocation of licenses for importation of solar panels from Taiwan to US. It was foreseeable because the relevant law enacted after signing the contract was in discussion and known before. They knew that it was arriving. Centro de Arbitraje de Mexico is interesting. And here it's a Mexican grower who did not supply pumpkins to a US distributor, invoking as force majeure the torrential rains caused by El Nino. This is atypical, but this event is recurring every 2 or 3 years. And so it was not foreseeable that it would recur in that moment, but it was more or less foreseeable. Dutch seller, Turkish buyer. This is a case where the buyer buys a plant for making sugar, but then the price of sugar gets down, and he said, "I am no more interested." But that's not an unforeseeable event. It's within his risk, no? The other investor, African state-owned company, here also the joint venture made with the African state doesn't achieve its objective due to social unrest, which is a typical problem in certain countries. And the state-owned company says, "Oh yes, it's force majeure." And the arbitrator says, no, the change in the social climate was foreseeable and should have been taken into account when negotiating the agreement. The second requirement, impossibility, somebody has already said something about it. It should be not absolute impossibility, but a more flexible notion of irresistibility to be assessed on the basis of reasonableness. This is certainly a trend. I always like this case which regarded the construction of an airport in an African country, and where the arbitrator says something that is interesting. When events beyond the control of either side supervene, which merely render performance financially more onerous for the contracting party, he will not, under most systems of law, be excused from further performance, or in the absence of some special contractor, entitled to insist upon a compensation, extra compensation. But when events which go beyond merely increasing the financial burden on the party performing, and which reach a point where they render performance unacceptably hazardous to the lives and safety of those performing, are in a different category altogether. And then they said, but I forgot to put this, that if you have to cross a place where there are mines, no, it may be that it's not impossible to cross it without dying, but it's not a reason for saying that you should do it. So the second, always here, the big problem is procurement risk. Most companies are convinced, and it looks like this if you look at, if you don't consider well the CSIG, that if your supplier cannot give you the goods because of a force majeure event he suffers, then you would be able to invoke force majeure. This is absolutely not true. It is your responsibility as a seller to provide the goods, and it's your risk that your supplier suffers force majeure. And so if you cannot obtain, you are breaching your contract. So here there was, it's a famous case, National Oil, Libya, and Sun Oil. There was a travel ban to Libya imposed by the US government, and the arbitrators denied the force majeure because they saw that other companies were able, because the company could not bring its personnel because of the US rules. And then other companies were able to bring people who were not US citizens, and so they said it's not impossible. And this is the big aspect, no? That impossibility does not exist if somebody else can do it. If you could have done it anyhow, without in reasonable conditions. But of course, it may be more expensive for you, and that's not a reason for saying that it's force majeure. So that's, I think, an important point. Then, event beyond the party's control. I think this is rather important because this condition has a substantive impact which goes far beyond what most companies imagine. In order to be exempted under force majeure, the impediment must be beyond the sphere of control and the risk of the party invoking force majeure. That's the significance of control. A party cannot invoke force majeure for events which are within its sphere of risk and control. So first of all, procurement risk, a supplier who does not obtain the goods from its supplier due to force majeure of the letter cannot invoke force majeure. And here we have a provision of the CISG which creates confusion, because Article 79.2 of the Vienna Convention says, if the party's failure is due to the failure by a third person whom he has engaged to perform the whole or part of the contract, that party is exempt from liability only if A, he is exempt under the preceding paragraph, and B, the person whom he has engaged would be exempt if the provisions of that paragraph were applied. So this clause, which apparently can apply to the procurement risk, actually does not apply. And there is, I don't know, there was a position taken under the CSIG officially which said it applies only where the producer seller has delegated the execution of all or part of the contract to a third party. So there must be a restrictive interpretation of this provision, and we must not have the illusion that it has the significance that apparently we would give to it. So then, beyond the party's control, I come back, procurement risk, I think it's not... I have cases here. Le défendeur qui a choisi le fournisseur pour l'exécution de son contrat avec le demandeur doit être tenu pour responsable du comportement de celui-ci. So this is important to better understand what it means. The third condition overlaps with the other two requirements. Here there is a bit. An event must be considered foreseeable for the party which has assumed, even implicitly, the risk. It's not a problem. It is as if it were foreseeable, because the party has taken the risk, and so the party must, even if it's unforeseeable, it's for the party. An impediment cannot be considered unsurmountable if the affected party bears the risk of non-occurrence. And I think these aspects are rather important. I am coming to the end. I have 3 minutes. I'm doing well, I think. Here we have examples of beyond the party's control. Cessna, Gulf Jet, a Dubai company, failed to pay the lease installments of aircraft supplied by Cessna and invoked force majeure because of the serious economic crisis which prevented it from carrying its business and collecting the income needed to pay the lease. The arbitrator rejected the force majeure exceptions because Gulf Jet assumed the risk to generate revenue from its business. A CETA case, I go further because I am a bit late. Then the obligation to timely notify the event, I think, is certainly important. We have seen the ICC force majeure clause says that the exemption does not take effect until the information is received. The CICG has a less stringent provision. The party is liable for damages resulting from the delay. Here we have awards, but I will go on because it's too late. I give myself 2 minutes more. The principle of perpetuatio obligationis, I think this is important, is interesting at least. Parties challenging force majeure sometimes invoke this principle, recognized in most civil law systems that the debtor in default cannot avail himself of the force majeure event occurred when he was already in default. International arbitrators have shown little sympathy for this theory. They find very often the way to avoid it. So here there was this general dynamics, Libya or road in Algeria, that is a case where I was the chair, and we have said, par la prévision d'une clause de force majeure détaillée, inspirée de la pratique courante des contrats internationaux comme celle prévue à l'article 18 du contrat, les parties ont montré qu'elles désiraient se soumettre à une réglementation relativement autonome de la force majeure, ce qui implique la volonté tacite d'exclure l'application de normes de la loi nationale applicable contenant des principes qui ne correspondent pas à la pratique usuelle dans le commerce international comme l'article du Code espagnol. So the idea is, no, it's not. So conclusions, I finish with this. I am a bit out, no, I'm almost in order. I think it's interesting to see how in this Babel, you say, tower of rules, the arbitrators tend to follow a somewhat uniform approach to the main problems. Why? Because I think they are aware of the fact that the problems are the same, and when the problems are the same, they try to give similar responses. Of course, we cannot foresee what an arbitrator will do because we don't know how he, but if he's an experienced arbitrator, if he knows the business, he understands the business, then there are good reasons to believe that he will follow this trend. And so I think for parties, it's important also when they are making their presentations in the arbitration to know what are these trends and to be able to mention some specific cases. I think that's all. Thank you for your attention. Kel.
Fabio, ci sono già delle domande sulla tua relazione, vuoi rispondere adesso?
Va bene. Some questions? It seems that there are some questions.
Online.
Online.
Dr. Schober, about foreseeability. Imagine a country throwing nuclear bombs. He says that everything now is foreseeable. What is the necessary level or degree of foreseeability?
For nuclear bombs?
No, it's an example. Imagine a country throwing nuclear bomb, performance getting impossible, but what was it unforeseeable? Is that an example? And then the question is, what is the necessary level or degree of foreseeability?
It depends on the arbitrator. I think it's something that you must evaluate. It's a bit a criteria. It's difficult to say before. Of course,
and then
a nuclear bomb is not very foreseeable. I don't think really, but so you have to decide case by case, and of course there is some flexibility in taking. You cannot set a general rule, but when almost everybody should have known and should have understood something, then it's foreseeable. But there is discretion on this, and this is something where, of course, I don't think that we can state any rigid rules on this.
Before Professor Erdem says something, Giuseppe Sito adds that you can really claim pandemic or war is unforeseeable.
No, pandemic or war is not a problem of foreseeability. Pandemic is normally unforeseeable, but the force majeure does not regard the foreseeability of pandemic, but regards the foreseeability of the measures which have made it impossible for you to perform. So you must always look at the fact, why am I pretending that it's impossible for me to do what I have promised? And if this is something that I could have done anyhow in different conditions or spending more money or whatever, then it's not a problem. So, and this is, I think, really for answering these questions, I think it is important to understand the cases. The cases help you to understand and to put the borders between what you can do and what you cannot do. Other questions?
Professor Erdem wants to add something.
Yes?
Few comments on that. First of all, so you may say everything is foreseeable today. There is nothing unforeseeable really per se. But what is unforeseeable for the concrete case? The fact that an atomic bomb could be done, it's foreseeable, but does it foreseeable that it will prevent the performance of your contract with respect of the pandemic? So we know pandemic, we have the bird flu, but we don't know that COVID will last for 2 years and we will not be able even to go out of our houses. This might be unforeseeable and prevent the performance of the contract.
Perfect, yes.
Jean-Paul, it's not, he's not.
Just an additional point. the pandemic as such, under the control of the medical doctors, does not make anything impossible. As you said, Fabio, the sanctions might introduce impossibility. But this is another component of the force majeure. Pandemic doesn't make anything possible.
Of course.
Yeah.
You must look at the effects of the pandemic.
Anna
Other
wants to add
question?
something.
Anna.
No,
To answer.
a very small comment on, just to add a very small comment on this. I think what happened recently made us rethink the idea of risk-sharing alternatives in the contract. So even going beyond the elements of traditional foreseeability or avoidability, if parties in long-term contracts can think about the fact that there might be those situations and then find appropriate rules in the contract to address them. So not only commercial contracts in general, but we saw it also in the agricultural sector, for example, where more details are usually provided, or methods to solve disputes, which try to find a good balance of the interests of the parties are also people are trying to, and both legislators and contractual drafting, and also UNIDROIT, FAO, and IFAD in the legal guide on contract farming have tried to do. So.
Another online question from Marina Brunazzi. Due diligence obligations and risk assessment could make the force majeure clause less and less applicable, don't you think?
Due diligence, I don't know really. I don't see it so clearly. I should have an example. Do you see it more clearly, Jean-Paul?
I do not have an example, but this brings me back to the old French wording of the force majeure clauses, which tends to disappear. We used to say unpredictable and or excluded by the provisions of the parties. And this is probably what this lady refers to. If you have the time when preparing a contract to really monitor or to go through all possible risks which you can reasonably identify, this would probably reduce the scope of application of the force majeure. That's probably what she means. Yes, she's right. But it supposes that you have the time when preparing the contract.
I understood differently the question. So you conducted a due diligence and you understand that there is a possible cancellation of permits by the government. So you see the risk, but can you overcome this risk? Can you reestablish the permits? Because this is a governmental act and you cannot overcome it. So in my opinion, the problem is with the consequences. So whether you have the possibility to overcome it or not. It may be foreseeable, but whether you can overcome it, then this is what makes sense.
I perhaps do not agree in total with you. Is it? That's okay. I think if the parties foresaw it, they may also see, they may provide who has to take the risk. And if one party has to take the risk and she can't overcome it, nevertheless, she has to bear the risk.
Sharing the risk is completely contractual, and this is another story. This is the purpose of the due diligence, in fact. But provided that see the impediment, the party provide a solution and share the risk accordingly in their contract. Then the contract prevails, obviously.
Of course, if you take the risk, then you cannot invoke force majeure if you have taken the risk, and this is obvious. Okay, I think that there's a last question.
Giuseppe Sito, I'm leaving another question on hardship. Clients are reluctant to accept a general principle such as events have rendered the performance more onerous than could reasonably have been anticipated at the time of the conclusion of the contract, or the presence of an arbitrator deciding on these matters. Any compromise solution, maybe escalation formulas on prices of materials, or in any case, a threshold of cost increase that the contractor can absorb, but beyond which contractor is indemnified. Any suggestion?
Okay. Suggestion is very easy. Of course, if you have a clause which permits to ask a third party to remedy, to reinstate the balance of your contract, you take a risk. And you have more ways to go to remedy. One is to create conditions where the problem does not arise because you have contractual conditions which help you already to overcome certain problems like price increase and so on and so on. The other one is to have a hardship clause that is more detailed and that gives, and this is what our colleague Pascal will tell you about later, is how to organize clauses which provide already general principles which must be followed, which provide a system, a structure where the two parties have to propose solutions. And so where there is a real discussion about the contents of this, because of course an arbitrator who decides what is right and wrong without knowing everything will be very dangerous, and parties fear, of course, that this happens. So they must provide systems which organize this discussion, which is very difficult because reaching a balance between two parties is something so complicated that the third party has a certain difficulty in understanding what you have to balance and in which way. But you can try to provide rules that helps you or systems that help to do it. And this is your role later. Thank you very much. Okay, questions and answers. We are...
May I ask one question?
Yes?
Apologies, because I have to share with you a couple of points which I found particularly interesting. One is on sanctions. The sanctions insertion in the force majeure clause.
Sorry, I don't hear very
Sanctions, on the sanctions issue on the force majeure. What we are at the moment seeing in practice is that we are using a special clause for sanctions in the contract, because there are what you find in the world of sanctions, you have directly applicable sanctions, for instance, the European Union sanctions for us in Italy, but they are mandatory rules of law. So it's easy. What is more difficult is the impact of non-directly applicable sanctions, like the United States sanction with extraterritorial reach. In that case, we really are a little bit lost. And in order to overcome this issue, what we are doing at the moment in practice is we are using a special clause to cater for this phenomenon, with the suspension of the contract, a rebalancing of the contract, and a termination after a while. Some sort of a hardship clause revisited in the source of sanctions in order to cater for that situation. That's what we are using at the moment in practice in order to overcome this situation, because there is a difference. For instance, English jurisprudence looks at extraterritorial sanctions as an actual impediment. Our jurisprudence cannot, if not for the blocking regulation. So we are a little bit stuck there. The second issue is just to show a scar on my body, which is on hardship. Working for many general contractors, we have serious problems at the moment with the enormous increase of materials. And what we are doing at the moment all over the world is we are revisiting all contracts to see whether we have clauses allowing us to increase the price or to revisit the price. And it is particularly interesting, this exercise, because we do not find in all contracts those situations. And for instance, in Latin America, what you see is that you can have new contracts with new polynomic clauses. All the contracts is very difficult to apply them. And this creates a huge problem for general contractors, for contractors on international arena. So this is very much welcome, this conference for these reasons, because sanctions is a terrible problem at the moment. Hardship is another terrible problem for our industry, at least for the Italian enterprises going abroad. Thanks for this conference, which is very much welcome.
It is interesting what you have said, because in ICC force majeure clause, sanction is a listed event with embargo. So we treat them as an event of force majeure while you treat as an event of hardship.
Yes, but if you treat as an event of force majeure, in certain cases, it is not even a force majeure, it's just an impediment by law. Because if the law tells me I cannot provide you with a certain good, I cannot provide you, it's force majeure or whatever. And then the consequence of that is the contract is frustrated because I cannot provide it. We are issuing legal opinions on these matters, which is called in the contract not strictly a force majeure. We call it a sanction event in the contract, and the sanctions event is triggered by legal opinions to this event. So it's a very interesting issue.
Okay, I think it's very interesting. Of course, if there is a sanction, and if a party says, due to the sanction I cannot deliver, then I would ask that party, but is there a way to avoid the sanction? Is there a way to bypass it? If there is a simple way for doing it, then you should use that way, even if it's more expensive. The other thing, if they are negotiating a contract, I would say, you fear this, this, and this. Can we provide and agree on clauses which solve the problem before and where we agree on the consequences? Because if we agree that we may suspend performance in certain circumstances, then it's agreed and it's okay. You wanted to add something.
Just to add two things. One is that there will be a specific discussion, I think, later on the sanctions. So this is a great anticipation of what will be discussed, and I think it's good to do it even now in the more general context. My second point was just to say something which might be obvious, but if there are default rules, they are useful when parties do not have the possibility or the time, or something happens that they cannot actually agree on a clause, or they do not have the time, or it's too costly, for example, smaller enterprises to enter into these long negotiations regarding clauses. And so the existence of reasonable default rules on force majeure and hardship, which take the needs of commercial practice into account, even if they're a bit more general, it's still quite important. But of course, as was said now, the situation that we lived through made us aware of the fact that inserting this type of clause, and particularly the hardship clause, in certain circumstances is something that parties should be aware of. And so all this, talking about the ICC clauses, has also this important effect of making all parties aware of the fact. Thank you.
I think we have forgot that at 10:10 we had Jean-Paul and Emiliano Berti. And so I think that we have anticipated the questions and answers, I would ask them to come here. And I don't know if I would leave the place to them or not. I remain here in the middle. Sorry, but I'm sure that my colleagues, we are all people, Latin people, and so I think that we are used to improvisation and we are used to adapt ourselves to conditions that were not foreseen, that were unforeseen and unforeseeable, perhaps, I don't know. Okay, so you have slides or?
Slides prepared by.
A couple of slides.
Yeah, apparently they are already charged over the system.
Yes,
Yeah,
I don't see them yet, but they will come. Okay, thank you, and sorry for having lost some time. We will shorten our coffee break, perhaps. I don't know what we can do.
Can you hear me now? Yes. So I think force majeure and hardship are really the hot topic today, because what we are experiencing all over the world in the last 3 years is something probably unexpected, and for sure something incredible that is one event after the other affecting our life, and consequently, as we lawyers, we commercial operators, corporations are dealing in the market, and the situation has changed dramatically in a way that what we could have relied until yesterday, today doesn't exist anymore. So we need to rethink in a sort of a Copernican revolution how we approach the contracts, how we approach the reality, how we set the perimeter to defend our rights. So together with a much better speaker than me, Professor Jean-Paul Villetti, I think today we will bring you through some practical examples, some real-life scenarios where probably we can not answer your questions, not provide a definitive conclusion and close the loop, but at least we can raise some points that can help us to think about and assess a little bit better in the future how we draft our contracts.
Thank you. We're not going to do anything academic, and in fact, we're short in time. So I propose, this was agreed with Emiliano, we will hand the micro to you quite rapidly. What we talk about, I pick up on what Erkumen said before, we talk about here situations which are basically foreseeable. We are not talking here about someone asking us how to save the situation of an old contract now after COVID or the Ukrainian crisis. We talk about people entering today in a contract knowing that you have over the head the sword of a pandemic, another one, a crisis, a war, a shortage, etc. How to address this in a clause. When we prepared a session today together with Fabio, the key message under your control, we think that most of the force majeure hardship clauses circulating around the world do not fit to these situations. This is what I said before. Just after the breakout of the COVID, all of us, we had hundreds of phone calls. I had my series of phone calls as well. People asking, I can no longer, it's going to be impossible for me to perform. Is it a case of force majeure? I said, no, pandemic doesn't prevent you from performing. You still have your staff, you still have your, but the sanctions might prevent you from performing. So this was their first surprise, that the force majeure clause was absolutely not tailored to the situation. So what we're going to take you through today is a couple of thoughts on how to, today, when you enter into a contract with the background we all know, which is today foreseeable, how to structure a clause, either force majeure or hardship. In fact, both situations today are interconnected. When I started teaching these two concepts years ago, we made a strict difference between hardship and force majeure. In fact, today you have a sort of huge bubble, which we can call disruption of the contract. And depending on whether it totally prevents you from supplying or only makes the performance more difficult or more complicated, you will opt for one direction or the other, depending on what you have provided for in the text. I don't know if you agree. This is the baseline of our presentation. We are not imposing you academic solutions. We want to dialogue with you. Emiliano?
On my side, I will try to give a quite a practical cut to this discussion. I'm not a professor. I'm not an academic. I am someone really on the ground. I am leading the department of legal and compliance of an international corporation, and I'm responsible for Europe. So I am overlooking 66 countries, and unfortunately or fortunately, in the last year, I dealt with Russia, with the situation that you all know, and I dealt with the pandemic. I dealt with the scarcity of raw materials and the unexpected energy shock we are facing today. And all this, as you can imagine, was not predictable until a few years ago, few months ago. But as a matter of fact, we have entered contracts years ago and months ago, and now we are dealing with a situation that has been somehow flat for years. Price of steel, price of aluminum, price of iron, price of energy, price of crude oil, more or less flat in the last 10 years. Now, as you can see from these charts, in the last months, everything is going up massively in a way that we have to rethink how we are doing business. And as my co-speaker just said, we are now entering into what we can call a new normal. New normal means, as a matter of fact, if we are contracting now, today, we cannot say, hey, I didn't notice there is a war in Russia. I didn't notice there are export control constraints impeding me to deliver some products in Belarus and in Russia. I cannot say, hey, I didn't take into account the cost of energy because I thought I was paying 90 euros per megawatt hour. Otherwise, we are talking about 250 today. So we are in a dramatically different situation, but we are still to do business. So this situation somehow is affecting how we draft our contracts. And in a while, because we discussed a lot about this, so do we want to provide a solution? Do we have a solution? How are you dealing with this? And as a matter of fact, we are really in a sort of de jure condendo situation because we don't have the answers. We are playing by ear, really. Everything is new. Also, let me say, I would go a little bit farther when we say, for example, sanctions are probably a force majeure event. Not necessarily. It depends what is your point of view. Because when you are dealing with a Russian customer, I can tell you they have their own view that sanctions are unlawful and they are not applicable to them. Otherwise, there are counter sanctions applicable to Western companies that we do not recognize. So we are in a situation where in the near future, we are probably to face unpleasant judgments in Russian courts. And then a very difficult execution, enforcement of Russian judgments in some countries, because we have some part of the world where these judgments will be enforceable, other parts in Western countries where probably they can hardly convince a courtroom to apply and recognize, first of all, the rendered judgment in Russia. So this is really something new. And for this reason, in a second, we will tell you how we have thought about and around this. Please.
Two further points. First of all, what Emiliano just said is absolutely fundamental. The perception of what we call the sanctions might be totally different on one side and the other. And this might give problems when it comes to enforcement of a decision, a Western European decision, which would consider the sanctions to be enforced in a country where they do not consider the sanctions are legal. This is an extremely important point. What we want to elaborate with you now is the step from identification of the risk to the allocation of the risk, because this is exactly what it is about, without flagging it as a force majeure or hardship. And we have, on the basis of the notes we received from Fabio, we have identified two categories of risk: the shortage and the price increase. Shortage, what is this for a sort of risk? You are short of goods, you are the supplier. As long as you can, well, you do not have your immediate supply anymore, you do not have enough on stock anymore, but you could still go to alternate sources. So the performance is still possible, but might be significantly more complicated. Or it really comes to a definitive shortage. You do not have the possibility anymore to provide the goods. I think it's progressively the case with microchips, because neither you nor your competitors, and no one on the market is able now to provide them. Then we come close to impossibility. Impossibility under your control again, I think under every single sky in the jurisdictions we know, impossibilium nulla est obligatio. You can't force someone at gunpoint to perform something which is impossible. This is a risk. And then your contract had to attribute the risk to someone. Usually, this was in the notes of Fabio in the program, the procurement risk is on the shoulders of the supplier. Should it still be the case in your contract? Yes, no. This is one of the elements of the bargain. Probably up to a certain extent, you can still say to the supplier, Guy, I expect you to do some efforts and to bear the risk, but starting from a certain, we say in French, seuil de douleur, threshold of pain, you have to allocate the risk in a different way to share the risk. Price increase can be linked with the shortage. Perhaps because of the shortage, you can still supply the goods from an alternate source. Instead of having the goods provided by a German supplier, you have to cross the ocean and to take them from a US supplier. There is an increase in cost. Still possible, but who is going to bear the risk? Again, you have identified the risk. How do you allocate the risk? Again, the risk is basically on the shoulders of the supplier, but from a certain threshold of pain, your contract should try to allocate the risk in a reasonable way. We made a couple of thoughts. Are they on the screen? Is it there? No, I think it's
next one.
It's the next one, exactly. So these are the thoughts we want. We do it. We accelerate. This is the discussion we wanted to open with you. We put in the form of a bullet list our ideas. When you assess the risk with your counterpart, and you try to allocate or reallocate them. We are no longer in the context of the force majeure and hardship clauses. So probably these situations should be dealt with in separate clauses. This should be, I don't know if you agree, but this is the point to which we came. We're not talking about force majeure or hardship, we're just talking about the allocation of a risk of disruption for events which are basically predictable, but which are not in your sphere of influence. I'll come back to what Fabio said before. You said sphere of risk, no? I prefer the word sphere of influence. So it is really something you can't help. This is really independent on any fault of yours. The situation should clearly be disconnected from any sort of penalization. This is clearly mentioned in Article 79 of the CISG. You cannot be sought for damages or penalties. I don't want Emiliano. You want to comment on this? Perhaps this was one of your major points.
Yes, absolutely. So, just one step back. So, can I? Oh, thanks. What we try to do is to, let me say, divorce from the concept that we can protect contractual situation from a legal perspective. Meaning that, to the extent that the concept of force majeure and hardship would stay anyway, we are just moving further the perimeter, because we, as usual, I would say, prepare the starting assumptions where we are basing our contractual synallagma, and then we decide what is unforeseeable. But then when we discover, or we have just to admit that we are not capable to foresee the unforeseeable, as a matter of fact, we have to work on other non-legal clauses where we can find a right shield to defend our position. For example, the penalties and the liquidated damages, because when you already know that you will be in a shortage of material, and most likely the timeline of your delivery wouldn't be met, as a matter of fact, you should try to relax, to extend your delivery dates. You should try to include a grace period in order not to get the penalization from day one of delay. You should try to make your penalties a sole and exclusive remedy. So these are all the ways that could help you to protect your contractual position, despite they are not legal clauses in strict sense. And we will go through some of these, let me say, contractual way out that are not strictly legal. And probably you want to discuss the others, and then we enter into them.
So how the clause could look like, or what it should contain. In the thoughts we made, so it should be separate from force majeure and hardships. It's a totally different baby. In terms of drafting technique, we think that the model general description plus examples is a good structure. It would cover all the situations of disruption, which, although they are foreseeable, are irresistible and not faulty. They are not imputable or attributable to the sphere of control of any of the parties. Grace period, Emiliano mentioned this. Grace period, this is, in my old conviction, one of the key features of all these clauses. If you resort to the domestic law regulation on impossibility, for instance, in Swiss law, when the obligation is impossible, it immediately stops. L'obligation s'éteint, the obligation is extinguished. Same rule in Turkish law. In commercial contracts where you have huge interests at stake, saying all of a sudden, guys, game over, is totally uncommercial. So let's introduce, I think today this is widely admitted, but this is the blood and the heart of hardship and force majeure. You introduce a time of observation. You propose now in the ICC 120 days. Perfect. Reduce or more. Disconnect from liability, liquidate damages and penalties, and then the essence of what we want to discuss with you is the threshold, if you agree, because there is a certain point where you can no longer say to the party which had the procurement risk, the risk is still for you. You cannot. This is what I call the seuil de douleur, the threshold of pain. So how to introduce in a clause this threshold? We exchanged ideas, and we do not have strict figures. But one of the possible scheme is that you agree on pre-agreed percentages. You would say, for instance, if there is an increase of price of between 60 and 100%, the first tranche between 60 and 80 would be shared 70-30, and the second tranche between 80 and 100 would be shared 50-50, or things like this. So this is a possible mechanism, of course, to be negotiated at the outset. You can't negotiate this when you are facing the problem. The other possibility is to put into the contract an agreement to agree, but here you face the risk that when you are facing the problem, really the acute problem, it will be more difficult to agree on a revision. I think there might be enforceability issues as well in certain jurisdictions. Certain jurisdictions do not admit very easily the enforceability of the agreement to agree. So you could not necessarily bring your counterpart to court to do the agreement on which it agreed. Fallback position, this is what is in the ICC clauses, or the UNIDROIT, is to ask a court to step in and to amend the contract along parameters which you would have defined. If you do not have defined the parameters in the contract, it would be more difficult for the court. Again, there is one reservation I make here. You have jurisdictions in which the courts cannot put their fingers into the contractual engine. They do not have the power to change the work of the parties. This is again under your control. And in Switzerland, and Switzerland is perfect. And then the last point would be the termination, but which is not commercially viable for me. The termination of the contract is the worst case scenario, especially in chain contracts, because if you terminate, all the chain is then affected. So these are the thoughts we made. And Emiliano, I don't know if you want to add something or if we open the discussion.
No, you said everything, because the golden rule remains to keep control over your contract. So wherever you are in the chain, if you have subcontractors, you should avoid not to negotiate back-to-back conditions with them, because as a matter of fact, subcontractors should swallow pro quota the same risk that you are swallowing with your prime contractor, with your prime customer. Whenever you set up a termination clause, as Jean-Paul said, that's to us the really last effort. Otherwise, there are many other ways before termination to take into account. And one of them is, for example, the suspension before the termination. So there is a wait and see scenario that in most of the cases is just disregarded, because contractual parties usually pass from a full performance at top speed phase to termination. We may admit in good faith and reasonably that the contract at the moment cannot be executed. So instead of just terminating the contract, let's stop the execution for a while in a way that we both try to minimize the financial impact on our respective companies' interest, whatever it is. And then as soon as the situation evolves, we evaluate how to recommence the contract. So there are so many ways that we have to take into account when we draft a contract today. The inflation clause, as Jean-Claude rightly said, or price reindexation of the contract, because the price should evolve probably whenever we link the fluctuation of the price of the contract to certain key elements: energy, raw material costs, because in some contracts in specific fields, they wait a lot. in the contractual price. What else? Try to avoid whatever is not under your direct control. Don't take risk for scope of work undertaken by other contractual parties, because you cannot just guess and rely on the fact that the others will perform, to the extent, for example, you are the consortium leader and you are somehow clueless of the activities that other contractual parties should perform, but you have a joint and several liability. And today, considering the big question mark on how the worldwide situation is evolving, is a huge risk to take. So again, I am putting the accent and stressing you on the fact that probably we have to go beyond the contract and again, divorce from the pure legal contractual terms, because I don't believe in the future, or at least to the extent that we remain in this uncertain situation, a very troubled moment, a contract per se really protect us if we rely on the legal clauses only. Because force majeure, hardship clauses are for sure something essential that we need to include in our contracts, but alone, they are not enough. They are not enough. So whenever you are advising your customers, whenever you are advising your companies, if you are an in-house counsel as I am, to me, our duty is to change the point of view. Hey, sure, I will try to give you the best contract ever, but you need to make sure from the executional perspective, from the commercial perspective, from the delivery perspective, from the procurement perspective, you are covered, because otherwise it will be a bloody contract. Anyway.
We stop here first for the reason of time, and then opening the discussion, I think. Fabio, what do you think? Do we open the discussion?
Shall we have discussion?
Yeah. Or coffee break?
Because
There is a question online. How come the room...
now we have something that I am very much interested in, because I have asked some legal people of companies to discuss what they think about these clauses that we have made. We have done our best to do something that is really practical, but of course, it's very interesting to know from them what they think about it, what could be made better. And since the general clause is a clause which is the basis for making a clause, which kind of modifications they would suggest. So we have here a group which is chaired by a panel chaired by Gabriella Porcelli, who is General Counsel, Chief Compliance Officer, and Board Secretary of Iveco Group. So Iveco is Fiat, is ex-Fiat, and now what remains?
Comes from there.
Then we have Marina Mercante, Head of International Legal Assistance, ENI Plenitude. I don't know why ENI become Plenitude. She will perhaps explain. And then a good friend since years, Edoardo Marcenaro, Head of Legal Corporate Affairs, Enel Grids SRL, member of the ICC Italia Commission on Arbitration and ADR. That's all. I give the floor to you, and you can continue, and I am going to listen from far.
I beg your pardon. I'd like to say that please stay with us, because later there will be a light lunch. It's not on the brochure, but please stay here, not go away at the end.
Okay, hello everyone. Thank you first of all to Fabio for this invitation and for the valuable inputs that we've heard so far from the speakers on the conference at the moment. I think we have a lot of ideas and there are some learnings coming from the recent decisions that we've seen mentioned by Fabio Bertolotti on the one side in arbitration practice. There are several factors that are currently characterizing business activity. First of all, I would say that we are, and most likely we will be continue to deal with a situation of huge ambiguity in commercial relationship and business activities. So navigating this ambiguity in a way to try and prevent disputes or finding win-win solution, as formerly we've heard, I think is the approach that we as in-house counsel are taking on a day-to-day basis. We've been asked recently to learn, I would say that has come from far back in time, but most recently it happens, and I hear from colleagues that project management is supposed to become one of our soft skills, because sometimes we find ourselves in the need to help the business functions that we support to monitor closely the performance of an agreement and not to stop with execution, properly recording, and then maybe step back to the document when there is a substantive amendment. Performance and monitoring performance is becoming actually critical to prevent this kind of situation or to identify force majeure elements or situation of extreme complexity in the performance that require an adaptation. Based on that, I would say that it's only the practical experience that we do on a day-to-day basis that helps really preventing a situation or correctly trying to draft the contract clause or interpret this in a collaborative spirit with counterparts. But more and more we've seen situations where this is becoming increasingly difficult. I will leave the floor to my colleagues, to Marina Mercante, beside a former colleague of mine when I was in oil and gas many, many years ago, unfortunately, and to Edoardo Marcenaro. I am currently General Counsel of Iveco Group, that is a spin-off from CNH, with basically having all what we call the on-highway commercial vehicle business of formerly CNHI, so bus, trucks, defense vehicles, firefighting, powertrain, and financial services. We are a company where there's a lot in terms of international contract management on a daily basis. And we have been struggling, especially over this year, that is our first year of life after spin-off and listing on the Milan Stock Exchange, of the severe situation that have affected contractual performance. So what we've heard before in terms of cost of raw materials, difficulties in performance in some countries, I would say rather than the effect of the pandemic, but not only that, the increasingly difficult situation to actually perform some agreements based on situation of impossibility to access certain countries, certain areas. Having said that, I would leave the floor to my colleagues for a first introduction of their experience, and then they have presentation that they would like to share. From that, we may draw some conclusion and maybe go for a few questions. Thank you.
Good morning to you all. My name is Marina Mercante. I work with Eni Plenitude and currently as head of international legal assistance. But as Gabriella said, I've been working for many years, almost 26, 27 years in the Eni group, mainly focusing on in the oil and gas sector. And today, what is Plenitude? Plenitude is a company, so the Eni group is 100% held by Eni. And we are currently active in the retail sector, as well as in the renewable sector and also e-mobility. So the name Plenitude would like to show that we are in a totally different shape in respect of the oil and gas. And the presentation I will share with you today, taking into consideration this new world for Eni especially, and then the new market and the challenges that we are currently facing in this sector. Please.
Thank you. I am Edoardo Marcenaro, and I've been working always as in-house counsel in the energy sector. I started in ABB some years ago, and then I moved to Enel, where I am now the 22nd year counsel, having changed some jobs in the group, because I started with the construction of power plants around the world. Then I passed to M&A to buy all the various companies in the Enel multinationalization. And now I live on platforms. Basically, it's a completely different job because it changes a lot to pass from construction to license agreements, platforms, and virtual reality, which is quite different. So I think we can start with our discussion on force majeure.
Let's move to business, so someone would say. So I leave to Marina to present her experience at Plenitude, and maybe I will then pass on to Eduardo with a few comments afterward. Thanks.
Thank you. Now, I would like to start with a very, very few premises. Sorry, it's my job, yes. Okay, very few premises, just to focus. Just to tell you that as ENI in the past and as Plenitude today, we are involved, as you may know, in a wide range of agreements. This means that we may find ourselves vested in different contractual positions. So when we draft a clause, we have clearly to think at which is our position, which may differ from one agreement to the other. Today, I would like to focus on some agreements, which are the agreements relevant to the renewable energy sector, and mainly to what we call in the sector EPC, which are the engineering, procurement, construction agreements, which are mainly the contracts aimed at building, for example, a solar plant or a wind plant, and other types of supply agreements in this sector, as well as the power purchase agreements, because when you produce energy from a plant, you should be able to sell it. So to sell the energy, you may need to enter into, with a private party, a power purchase agreement. We are still in the process of customizing and adapting our contract to this new market, because we are pretty new to the market. We are in the renewable sector, especially since few years. So since the new board, let's say, of Plenitude, and also the rebranding, we're also trying to customize our draft, so changing also our model form. And so today it's also the occasion to gather some input from all of you, so to have an evolution of our also standard agreements. I would like to start with a very practical example, and a recent one because we, following the Ukraine crisis, we received a force majeure notice. This is, in my opinion, an example of what not to do at all, because that notice was really lacking all the necessary elements of a force majeure notice. First of all, it was provided almost 100 days after the inception of the event, which, as you may know, the war in Ukraine started late in 24 February of this year, and the notice was provided in June. It was a notice really vague, which did not provide any detail on the event nor any evidence. What they wrote, and is what I reported here, it's what you can read, which was not enough, clearly, in our opinion. Also, the notice made reference to the war in Ukraine, while the country where the contractual obligation had to be performed was another one, was the Kazakhstan, because this counterparty had to deliver some goods, some spare parts to Kazakhstan for building a plant. And they justified their impossibility, let's say, not impossibility, sorry, they justify the increase of the cost for performing their obligation on the basis that they had to choose another route to deliver the goods, which clearly, as you all know, this is it shows that the contractual obligation was not impossible, simply had implied an increase of the cost, so it should better qualify as hardship, not as force majeure. And this is the reason why we fully rejected the notice. As a matter of fact, they didn't reply since then, so at all. but this is an example I wanted to share. It's quite a recent one. I think quite an important one to show it. It's not to be done. I would like to go ahead because I've been considering the ICC model clause, which I find very, very good, very useful, with the other clauses that we've been using in the different types and the different categories of our agreements. I think that I want just to make some thought. I'm not commenting in the sense it's not good, because I think it's really good. For example, I would like to comment that on the event qualified as compliance with any law governmental order. This is clearly a good example of event which may raise a force majeure, but it may also have an overlap, possible overlap with the change in law or the hardship, because clearly the law or the order of a government could give rise to a change in law in your agreement. The second one I would like to comment is the general labor disturbances, which are also read in the note to the clause, which is something that could be important. And for example, in our EPC standard, we make reference to the national strikes rather than general. I believe that maybe general could raise some issues, so maybe we should be more clear on what general means. So maybe clarify it in the context of your business or the momentum, or in any case of your agreement. And I would also like to comment about the fashion pandemic, the COVID-19 pandemic, for example. As at today, in our standard, we expressly say that the COVID-19 pandemic is not anymore an event of force majeure, clearly, because it's not unpredictable. But in some cases, if a counterpart is as requested, so in some cases we accept it, to say that in case there is an order by an authority which imposes a lockdown, which prevents totally the party from complying with its contractual obligation, clearly this is an event of force majeure. So we expressly provide this wording just to have the COVID-19, well, the order of the authority just being an event of force majeure. These are a few comments I would want to raise in respect of the list of the events which are present in the ICC clause. Also, in terms of the condition for terminating the contract, just a few suggestions. First of all, I also had heard some other speakers which make reference to this, to a possible intermediate step. Because in some of our modern standard clauses, we refer to the possibility of the party to meet, for example, after 30 days period, to decide what to do. And the party in that instance could decide to terminate at that point in time the agreement, or to continue the agreement and then continue with the suspension of the agreement. This, I think, could be useful, just to have the party not losing completely the contact during the long period of the suspension of the impediment, let's say. And so this is something that I could suggest to consider when drafting your clause. And also the duration of the impediment. We have been saying that we can choose 120, 90. In our standard, we have mostly 90 days, but sometimes we have also longer period than 120 days. I think it's important to consider in your agreement the duration also in respect of the other agreements which are related, connected to your agreement. For example, our EPC, which, as I said, is relevant to for example, to the building of a plant, of a solar plant, which has to produce energy. If I suspend for a certain period of time, I have also to take into consideration what happens to my other agreement, for example, to the agreement to sell the energy coming from that plant. So clearly, I should have to invoke also the force majeure under that agreement, but I have to consider how much time also that period can last. So it's really important in your practice to consider all agreements which are connected with the principal one. I would also to comment a little bit about the timing of the notice. I see that in the ICC clause, there is the possibility to have the starting day of the suspension as the effective day of starting of the event. So you have the choice if you provide without delay the notice. So the starting point may be the event itself. In our case, we normally have the starting date, the date of the notice. The notice is provided, served. So I think it could work anyway. Maybe just to be careful about this in case, because sometimes I feel it may be critical to understand when is prompt, when the notice is provided without delay. It depends again on the context, on the agreement, on many other issues. So just a point of attention, just to be careful when you think that your notice has been provided. Also because there is this implies a lot in terms of cost. If you have to decide until at what time you have to pay your contractor and then stop paying because the work was suspended, it's quite relevant in terms of cost for a company. Okay. Shall I go ahead? I wanted to briefly touch about the hardship clause because I have to tell you that in our current and also past experience, we don't have hardship clauses in our agreement. This is something we will have to think about, maybe to insert. In my past experience, and also today, mainly in the PP, in the power purchase agreement, we may have change in law clauses. And because in PPA could be relevant, because clearly the price is something that could have an impact, huge impact by the change in law. In some cases, we have negotiated in de facto, let's say, renegotiated the agreement. But this is important, so we will really think about it, how to adapt our standard agreement. What I have to say that in my past experience, in our agreements, I've never seen the alternative to refer to a judge or an arbitrator for the adaptation or determination of the agreement. Sometimes, in some cases, we prefer to refer to an expert which maybe we decide to appoint in a certain category of expert, because we have felt in the past that maybe the judge or the arbitrator has not enough expertise to deal with the specificity of our industry or our market. So maybe the expert, we have much more possibility to decide who will be, even if it's not 100% sure in practice, but I think it's preferable for us. And last point is that in our agreements, we have never provided for the parties' right to terminate in case of change in law or in cases which are similar, let's say, to hardship events. We will, again, try to adjust our agreements also because we are in I think that the standard agreements for companies are in continuous evolution because the world changes, the market changes, and so we have to adapt to the extent possible our agreements, and we'll do so. Thank you.
There is a first question. I read it now or later. About the EPC contractor. Is an EPC contractor. Yes. Giuseppe Sito writes, as EPC contractor, I see many clients now insisting on exhaustive list of force majeure events. Any experience on this? I think it's pretty unfair. I would rather have no list and only the general requirement of enforceability and out of control. Your point of view? Okay, later. Okay. It was only the kind of a contract of agreement we have just mentioned now. Okay.
Yes, we speed up probably the conclusion of the panel to then move. Just one comment on what Marina was saying is that it seems very important to try and preserve the scope and the objectives of the party, even when you could resort to some sort of solution like the adaptation of the contract driven by an authority, a third party like a judge or an arbitrator. And instead, it seems that somehow we move from adaptation to some sort of dispute resolution in an alternative form. This is basically an expert determination is one of the key alternative dispute resolution methodology. And another thing that was coming to my mind is that when you have a case that is an event that we would call a force majeure, but then the qualification of which depends very much from a practical situation. Let me give a very simple example. We have a significant country risk in Argentina at the moment related to various factors. And tonight I was informed that, for example, in my company had a certain number of vehicles already, ready to move to Brazil, stopped at the border between Argentina and Brazil, because overnight Argentina issued some new regulation about prohibiting export of certain goods to protect national economy. And this was a totally unforeseeable stuff. But clearly the other party that was supposed to receive this was saying, we just don't care. You should know because this is a country risk. To what extent the foreseeability of such a country risk can overnight be something you can include in a contractual clause? I don't have an answer. Eduardo, please.
Sorry. Where can I find my presentation? Here we go. Well, basically, that's the question. And this kind of question, just to sum up what I heard so far, I can simply say, without going through all the elements that we were already discussing in details, that it's a typical decision which cannot be taken by lawyers only. So in our business, especially in our oil and gas and energy sector, to talk about force majeure and terminate the contract can be a real problem, because it's not so obvious to terminate contracts when we are talking about providing energy to at present 40 countries around the world. So it's a decision taken by business together with the legal department. Our capacity must be to be, first of all, flexible in taking the decision, because sometimes if I have to look at the events, for example, I think that all clauses I've seen in my life for force majeure were including but not limited to, which I personally always translated into Murphy's Law, because the event which occurred was never listed in the list. So you had to go and restart discussions saying that riots were not disorders and revolution was not riots. And the discussion, especially when we were starting arbitration proceedings, were really fantastic, because looking at arbitrators discussing about the difference between riots and disorders and thinking about my managing director waiting for a reply, I was thinking, I hope he will never know it because he will fire me. So that's the kind of discussion we normally have. So business is fundamental, and that's the first point, trying to be fast and direct in my presentation. That's something we already seen this morning. That's my guidelines. I say it very openly. I got a degree in law some years ago on Lex Mercatoria. I've been looking for Lex Mercatoria for more than 30 years, and sometimes I found it. I found it because, for example, when we were talking with Anna and Fabio before about UNIDROIT principle and force majeure clauses, it's no need to go through all of them because we already seen it, but these are the real model terms, the model clauses we use in our business, especially when you go in countries where you do not know or you are not familiar with the legal system of that specific country. So I wanted to give you a practical example just to tell you that I'm not saying, let's say, dreaming about UNIDROIT and force majeure hardship ICC clauses. What happened March 2020? we faced an unforeseeable at that moment, I underline at that moment, situation of the pandemic, and we focused on long-term contracts. So our General Counsel, Giulio Fazio, organized a task force where we draft from scratch is not real true because we started with our fantastic UNIDROIT principle and our fantastic ICC clauses, an ad hoc clause to be inserted in all long-term agreements. I'm not reproducing the clause, of course, but that were the 5 points that we established in said clause. Acknowledgement by the parties that the contract was entered during a particular moment. Monitoring the consequence arising from that particular moment. Notifying any impacting event to the other party. Cooperation, I would underline, in good faith between the party to mitigate and possibly remedy the consequence of the situation. And if the effects could not be removed, renegotiation in good faith of the contract. We were not, let's say, inserting a third party, a third subject entering into the discussion. And I must tell you that this clause was spread to our 40 jurisdictions. And when we asked to check if it was compliant, if it was enforceable in 40 different jurisdictions, the reply was yes. And it was a great reply because that's the demonstration that when you start from UNIDROIT and ICC clauses adapting, because I mean, I don't know if I have to pay some copyrights or similar, but we were really going through the elements of UNIDROIT and ICC clauses to create our ad hoc clause. And it worked, it's still working. So that's the example I wanted to bring of a practical situation. Now, I will skip next because we already discussed with Fabio about the procurement, and I will finish with a question. What's happening in the various jurisdictions in this regard? Because I tell you honestly, I don't know if it was any development of this, but in 2019, we had a proposal of revision of the civil code, of the Italian civil code, which is so young to be dated 1942. So let's say it could be time to start rethinking about some clauses, whereby there is a proposal to introduce the right of the party to contracts which have become excessively onerous for exceptional and unforeseeable reasons to demand their renegotiation in good faith, or in the event of non-agreement, to request the adjustment of the contractual conditions in order to restore the economic balance originally agreed by the parties. So that was, in my opinion, a great proposal. It was not so obvious because I put 2 question marks. Maybe I here look at Fabio, Anna, Maria Beatrice. It could be another occasion of discussion in a next occasion, but this could imply to change the rules on the circumstances, I mean the general rules about Italian civil code, and it could be also a possible amendment with respect to what we were saying about arbitration on the principle of the integration of the contract, because at present our civil code accepts elements like the law or the usage, but does not make any reference to the decision of a judge, which I asked Fabio should be different with respect to what we have seen with all the arbitration decision we went so far. So I don't know if someone wants to give their experience in their country, if there was similar initiatives by legislators, because again, not to insist on UNIDROIT and ICC, but I do remember many discussions I had with my professor Alberto Mazzoni here in UNIDROIT, saying that these were elements which should also be used as model, not only by as operator of the international trade, but also by arbitrators, but also by legislators. And I think that's a very good point. Thank you.
Thank you, Eduardo. We see some sort of blurring borderlines between the role of arbitrators that are called to integrate and supplement some provision, the parties that try to preserve the scope of the agreement, and possibly also the applicable law that, from what we've heard before, is referred in a non-always consistent way in the context of dispute resolution with arbitration clauses. There are situations where the arbitrators tend to resort to applicable law to find some sort of measurement of the practical situation. In other situations, this is considered not appropriate given the tool that the parties have chosen. So I strongly agree with the fact that preservation is fundamental. The way to preserve comes from practical experience, but also from collaborating with the various legal operators. I would defer maybe to Fabio if he wants to say something. Otherwise, we could also listen to the various questions that have arrived. Thank you.
Only add, you have said hardship in the law is a good idea. Of course, the French law has it. Other countries have introduced a general rule that permits, in case of hardship, to go to a court or to an arbitrator and to get the contract amended. I have always been very much against this idea. I know I have criticized UNIDROIT on this point because I think that that kind of rule is not appropriate for most international simple contracts where it is excessive and it may leave space to parties that want simply get out of their obligations, even if, of course, the clause says what are the conditions and so on. But I think that in practice, we should not be against it, but we should exclude these laws and perhaps and make clauses which are adapted to the situation. And I think in particular, there are contracts, as you have explained, where it's obvious that you need such a clause. You need even that you can threaten to give to a third party to decide what is good or bad. And normally you will not go to a third party because you will find an agreement. So we must look at this problem in a practical way and not in a theoretical way. Not think what is good to the poor guy who is in a situation, we must help him in it. It's not so simple. But I think that we have tried to do something which is reasonable with our model form. And in our model clause, we exclude the recourse to the law, to a national law that would make it obvious that you can go to the judge or to the court. So this is a practical problem. I have understood from my friends who are in the companies that they fear very much that a third party can intervene in something that only they are able to understand and to evaluate and so. Anyhow, I think that it will be very interesting what you will say later on how to manage these clauses.
We have on the floor. Thank you.
Yes, thank you. Thank you for your observation and for your very, very valuable input. Perhaps I have to emphasize two things. The starting point of the foreseeability or unforeseeability is the time of the conclusion of the contract. So everything starts with the conclusion of the contract. So what happened then after, it's another situation. My first remark. The second remark, to proposal of Marina, whether we can have an expert determination, certainly yes. But what we thought in the commission, expert determination, it's some type of agreement of the party through an expert. It could be treated as an addition to the cost of the contract. Then, because it will not be conclusive what the expert says. It can be create other challenges. This is why we refer directly to arbitrator or to judge. And my last point with respect of the hardship, I didn't emphasize, but in the text, 3A, 3B, 3C, it's all started unless otherwise agreed by the parties. So the favor contractors oblige the party to even renegotiate by all means. They are invited to do so in good faith. But in the absence of any possible conclusion, we have to provide a solution.
May I? I just wanted to say that what you are saying is absolutely true about the moment of the entering into the contract. And if I have to give you my personal practical experience, this historical moment helped, just to say something positive in this particular moment, because created in business awareness, which is not obvious. Because I can tell you that the hardship and force majeure clauses were the typical clauses together with applicable law and jurisdiction that were negotiated at 7 o'clock in the night when we were lucky, 1 hour before signing, because the business didn't care at all, okay? Now it's different, because now they understood that a force majeure clause, which does not provide for epidemia, pandemia, or whatever demia you want, it can be a problem in 2 or 3 years. So now there is much more attention. I don't know if my colleagues are on the same, let's say, thinking, but now they really look at it. So it's very important regarding the matter of the moment we enter the contract. Regarding the third party, of course, it's a cost, because then we will start again a discussion about how much does it cost, how long does it last, which we know about arbitration. So.
Thank you, Eduardo. One last comment from Marina.
Just one question on the expert determination, which I'm quite interested in. But you think if we state that the opinion of the expert is binding on the parties, we can maybe solve the issues, because they're sure. This is what we have been doing actually in our agreement. So just to avoid what you said, that we spend time and cost in deciding and try to adhere to the expert determination. So just to thank you.
Okay, I would like to thank both Eduardo and Marina for the work. Just one thought for maybe ICC also, to try and think a little bit more about small and medium enterprises that somehow find difficult to afford complex adaptations / resolution methodologies, would still need some education about how to preserve the scope and the consent of the agreement, but there are actually those that are suffering more in situations like this, where cost of materials is increasing, uncertainty in international trade, and so on. I don't know how, but I think this could be a point for further reflection also within House Council. Thank you very much for everyone. Thank you.
Thank you. Thank you very much. It was very, very nice, interesting. I fear that it's difficult to explain to small businesses how force majeure works. They don't read, and I am sorry, I don't want to be, but they don't read possible explanations, and so I think that the only good thing we can do is to give them short standard clauses that are the less bad possible. I think but of course, it's true that we should and we will go on in promoting a discussion, as we did now also, on what is force majeure, what does it mean, how do you manage force majeure in your contract. But I am afraid that many smaller companies that do not have a legal expert inside the company will not participate very much to this idea. We can do our best, of course. We are always trying, to convince. I have been, for years, I have been explaining the law to people who do not know anything about the law and international contract, and I've tried to get them to understand the things that are outside their normal reach. And so, of course, the idea is good. We will see what we can do as ICC. I am, of course, at disposal for promoting seminars, perhaps, on the use of the force majeure clause, now that it is very important. So now
Fabio, if you allow me, I confirm, and we all can confirm that there is a great attention of ICC at a global level, at a national level, for micro, small, and medium enterprises, and there is a great effort to inform and promote education programs on such subjects. So it's a common effort.
I have been doing this for 40 years for the Chambers of Commerce, for everybody, even for the ICC. So I am fully convinced of the necessity to transfer certain notions to small and medium-sized companies. Of course, another thing is to know if they will be able and interested in a very specific point like that of drafting the best possible force majeure or hardship clause.
And then, Fabio,
that's a practical problem, but we must go on. We will do it certainly. So,
if you allow me a second thing,
yes.
Just for a few seconds, to read the message from Maria Vasilieko. It's not a question, from Ukraine. And she says, we faced lots of issues due to the stoppage of Black Sea port terminals, the murages, the Danube ports, and so on. Just several days ago, it was decided to stop electricity export due to attack on electricity stations in my home city. We appreciate that the attention of the European legal community is paid also to the situation in Ukraine, and we believe that thanks to common efforts, we would overcome all negative outcomes. I think it was important to read.
We all feel very near to, very close to our friends in Ukraine who are attacked without reason. So really, then of course, when problems arise, practical problems arise, I think that in these exceptional circumstances, the only way out is that of negotiation. You should not apply the law. You should not go and look who is right and who is wrong, because we are all right and wrong at the same time. The big problem is that we must find a way out that is good for everybody. And this is, of course, not easy. You must try to keep away lawyers that are too much lawyers, litigators and so, and try to put in their place people who know how to negotiate. Okay, now I give the floor to Pascal Akawi, and I expect very much from her because, as we have seen, hardship in general terms is something dangerous to say. Yes, when there is hardship, then if you don't agree, there must be somebody who gives you the answer of what is right and wrong. I think it's very important that if you imagine hardship situations, that you try to make specific clauses which take into consideration the situation that you imagine that is likely to appear in the future. Yes, so please, you are an expert of this, and I count very much on you.
Thank you, Fabio. I hope I would fit the expectation you put on me. I'm waiting for my PowerPoint. Yes. I will skip the introduction, but I would like to thank you very much for inviting me. Professor Bortolotti, Madame Veneziano, ICC Italy, thank you for being there to share some thoughts about the need to include a hardship renegotiation clause. Let me recall that hardship is a civil code concept that is different from force majeure because of the impact of the impact of the event on the contract. There are different concepts with different legal regime. This is for the application of the law. Now, why, and also I would like to give some answers. When you put a clause, you should bear in mind the applicable law because some provision on hardship are mandatory. It exists in almost all the Middle East, and also the Dutch provision on hardship is mandatory, which means that you cannot opt out of the possibility that it's stated for in these provisions. So the drafting of the clause should take into consideration the possible applicable law and the possible way of this, how this law is drafted. And hardship could be, named as various names: the alteration of the equilibrium, the excessive onerosity, the change in circumstances. It depends on the names, but it's the same concept that is dealing with. Now, hardship, as said before, is an exception to the performance of the contract. So whatever you foresee in the clause is restrictively interpreted by the judge or the arbitrator. Now, I will go, the ICC, you have all the ICC clause in front of you. The event should, the notion of reasonable is very important in the clause of ICC, which may not be provided for in the legal provision. So maybe it is adapted to the contractual commercial, the commercial contract. But I think that the notion of reasonableness will open the door to a more interpretation by the judge or the arbitration of what it is or what it is not relevant as an event of force majeure. What is important is the performance is becoming excessively onerous without any definition of what is excessive onerosity in the ICC provision, but still possible. And I also note that the burden party should anticipate or overcome the situation or its consequences, which in my opinion is a mix of what you expect from the party in the force majeure situation and not necessarily in the hardship situation, while in my opinion, it's better to put these obligations in the shoulder of the two parties while they are negotiating. This is my opinion. I mean, yeah. So the parties are still bound by the performance of the contract. This is the, what qualify the hardship in comparison with the force majeure, and they are obliged to negotiate alternative contractual terms, which reasonably allow to overcome the consequences of the event. It is welcoming because not any, let's say, not any adaptation is necessarily reasonable. And so it is on a case-by-case cases, depends on the nature of the contract, on the environment, on all these circumstances that has been dealt with by our colleague. The list that has been listed is very good. So now, very quickly, the intervention of the arbitrator, necessarily by one of the parties, be it to terminate the contract or to adapt the contract, which it makes the responsibility of the parties to call for the arbitrator for any of these decisions. So the parties still in the middle of the situation, and this is very important. It's not, we don't skip, the excessive onerosity and then we go immediately to the judge. The renegotiation of the contract by the parties is the core element of the hardship situation. Now, why it is important to insert? Because legal provisions on hardship have many solutions. You have the contract negotiation by parties is not always the prerequisite of the intervention of the arbitrator to adapt the contract, or you have the contract adaptation by the judge is not necessarily the foreseen solution. So if you want an adaptation, you should go to the negotiation and then to allow the arbitrator to terminate or to adapt the contract if reasonable. But these solutions are multiple and various in legal provision. And as you know, you have always an applicable law or rules of law. So go to look at these, and then you come back and you say, okay, I would like to insert a good, clear, tailor-made clause to my needs to avoid, the imprevisibility of any solution. Now, the contractual provisions also, as I already studied in a previous article, you may have different solutions, the adaptation or the exclusion of the adaptation. For instance, the party disagreement is excluded from the scope of the arbitration clause, which skip the intervention of the arbitrator to intervene in the contract, even to terminate the contract. So the arbitrator only assessed the situation of a hardship and tried to figure out what the parties did, but without intervening. You have also sometimes the termination of the contract at the end, if the parties disagree, which will favor the advantage party or the disadvantage party, sorry. And sometimes there is, the termination of the expert, as you did. So from a legal point of view, an expert gives, let's say, not a decision, but gives an advice or its idea on a technical term, This is not binding the parties unless the parties accept this solution and they would integrate it into their contract, and then it becomes binding to the parties. So the expert is not the end, it's not the beginning, it's not you gain times while you try to figure out what would be the solution. But of course, the expert you name is someone is from the field that you name when the event occurs, so you have time to determine which to, but the decision is not binding unless you accept it as a parties. So it's very important. I think it's not the solution. When this third party, the arbitrator, will intervene, just to say that anyway, the arbitrator as a judge will have to assess the conditions of hardship, no matter what the decision of the parties would be. It's in his role to assess if there is, events that occurs, what kind of events, what kind of the impact on the contract, etc. And should he intervene after the negotiation of the contract by the parties or after the agreement of the parties? ? All these questions should be answered on a case-by-case situation. Now, the new ICC clause make, as you know, the adaptation of the contract by arbitrators in case of hardship, etc., at the request of the party to adapt or not the contract. Now, to answer Professor Bortolotti's question, how, and this is the most important part, of course, of our presentation, what are the specific circumstances that are likely to affect the balance of the respective obligations of the parties? Here, what is the criteria that will determine the existence of an event that may qualify a situation of hardship? Is it the unpredictability of the event or its impact? And in my opinion, what is important is the impact, because as you say, I think that what we are facing today, pandemic, economic crisis, sanctions, whatever, and so on and so forth, I think that we will learn more and more. We are in a times that is very unpredictable. But what counts and what qualifies an event as an event of hardship is the impact of that event on the performance of the contract. So the impact is very important, and this is what I think should be clearly mentioned in the provision, just to make clear the intention of the parties that not an event as per se, because I mean, even in the event of force majeure, not an event in itself is qualifying a situation of force majeure unless a presumed list and encore. So you have an event, the impact, and of course all the criteria that will go with it. Now, what is the excessive onerosity? Also to the previous presentation, ICC does not define the excessive onerosity. Principle UNIDROIT that has my favor, and it's the increase of the decrease of the counterparty. So we have a limit, but here again, it's not enough. I think that a threshold should be determined according to the nature of the contract. Sometimes 80% could be qualified as excessive onerosity depending on the contract. Sometimes 20% of the increase of the price. So it is on a case by case, but I think that the parties should be, has the responsibility to anticipate what may occur according to their needs and to fix the threshold in order not to leave more space for the arbitrator to determine by his own power what is or what is not. Because the power of the judge is, in that situation, the approach is necessarily restrictive. So if you want to have it more or less restrictive, you have to put it in the clause. I'm talking to Annie because I think she's in the need of having, some information. So the affected party has to avoid or overcome the event and its consequences, ? And of course, it's resulted from the good faith of the performance of the contract. And not only the affected party, but also the advantage party should not take advantage of this situation and to move forward. I think that what we witnessed from this morning, and I'm very happy because it was the subject of my PhD, is that the parties should be responsible, not only the one who is disadvantaged. We are moving from the sanctity of the contract to the flexibility of the contract. So this is very new to hear because of the, what we face today. So we are into a new approach of the contractual relation, especially on the international level. More or less, we have the long-term or the short-term contract, but everybody is concerned. So the flexibility is the key. The responsibility of the parties, all the parties, is important. So I will move this burden to the two parties and not only to the burden parties. Guidelines and procedures. For renegotiation of the contract, you have parties should implement a contract negotiation. It's the beginning. The conduct of the negotiation is important because it's under the scrutiny of the arbitrator, under the umbrella of the good faith of the performance of the contract. And what is the scope of the negotiation? It should be put into the contract. We'll see why. Now, the burden party implementation of the contract negotiation. Of course, the notification is the key. I mean, the obligation to inform the other party is to put the parties into the step of, we are moving of the contract performance as what have been foreseen during the negotiation of the contract into a new situation when the two parties are, into a new situation and all the information should be put into this, label of the burden party. It should inform what is the event, what is the impact of the event, and to start the renegotiation if it is what you foresee in the clause. And of course, I welcome, and I think the parties should try to agree on the renegotiation because it's their contract and not the arbitrator contract. They will be much more happy to try to avoid the intervention by meeting around the table and put everything on the table. This is your responsibility at the end. So as soon as possible, so put a time limit, as soon as possible, when the burden party is aware or whatever, it's, formulated in a good way and ask for the negotiation of the contract. It is an important starting point. So now, conduct of the negotiation, I should put my word, but anyway, the conduct, it's according to the principle of the good faith. So you know, it's proposing and counter-proposing is the key. And you should, none of the parties should be, the parties should be aware of not trying to escape the contract, because at the end, the arbitrator will come and assess the position, and they will be held liable if they will try to better position the contract. These case laws are existing to ameliorate the position or to escape from the contract, taking advantage of this hardship situation to escape from the contract is not the issue, because at the end, when the arbitrator will assess as a judge, you will be held liable not to, to negotiate in good faith. The scope of negotiation, I will advise not to foresee that if the parties disagree on the adaptation of the contract, then the contract is terminated, because it will favor the disadvantaged party. So they will try, to escape from the contract. It will be a good way to give it the floor. Not also to maintaining the contract, because it will favor the advantaged party. Suspending the contract, it could be, everything is possible while you put it in the clause, but it's not the issue. What to do? How long? And at the end, why? If you cannot disagree at that moment, could you think that you will agree, 10 days after or 3 months after? I think it's not economically reasonable to suspend the contract in case of hardship. Just renegotiate it and just try to find a solution. And intervention of an expert, of a mediator, you have to define the exact meaning of what you expect from the expert of the mediator, knowing that the scope of these decisions are not the same. The mediator is not intervening in the contract, just trying to mediate between two parties, while the expert is giving an advice giving expertise. Now we come to the core of my presentation that is expected by Professor Bortolotti. What criteria should govern the choice of the arbitrator involved in the contract to adapt it? The question should be asked upstream, at the beginning of the negotiation of the contract. Don't wait, when you are in disagreement of the party. Don't wait. Just put in the clause. So what profile should the arbitrator have? Now, we know that arbitrator, as we know, we imagine, is someone who is fixing the line between, a conflict of two parties. But here, the arbitrator will have also a double hatting, to adapt the contract. He should, or she should be, not only have legal competence, but also contractual competence. For a construction contract, have an engineer having also, legal competence, but also he knows what the parties are expecting from him. He knows what it is about. So depending on the nature of the contract, try to think about a list of arbitrators that fit the requirements of the nature of your contract, so you will not be, disappointed by what power now to have. Keep in mind that if you give the power to the arbitrator to decide ex aequo bono or an amiable composition, it gives the power to the arbitrator to render, to reduce the rigor of the application of a rule of law or the contract clause, which means that this power may have the effect, not the object, the effect, to have the similarity of the clause by leading to the arbitrator who could reduce the excessive onerosity without even the agreement of the party, as the express the power that is given to act on amiable composition is an implicit power to reduce the excessive onerosity. So this is the articulation between the multiple clause in the contract. Now, the arbitrator methodology should interpret the meaning of the contractual provision, not adding or excluding something. It goes from the clause. He comply with the intention of the parties. and respect the contractual provisions already existed. And he should take into account the balance of parties' interest, the surrounding circumstances, the reasonableness if the clause include the reason, and the fairness and if justice also requires. So all this is taken from the clause. There is arbitrators' power to adopt the contract is not an obligation. In any of the clause, this legal provision you have, the court may, if appropriate, if it is reasonable. So it's depending on the circumstances of the case, the court, the judge or the arbitrator could terminate or adopt the contract. It will be a choice, but give him the power to, if you give him the power to adopt the contract, give him guidance. So what is the meaning of adaptation? It is the reduction of excessive onerosity. That's what it means. You have some examples taken from legal provision. You have some examples also here taken from the rules of law, UNIDROIT and PECL. PECL is different from UNIDROIT because UNIDROIT does not specify, while PECL to distribute in a just and equitable manner the excessive onerosity. It gives guidance, but it's not enough. Legal provision, the scope is just an adjustment. The arbitrator does not write a new contract, does not add new obligation. It is just an adjustment to what existing already at a reasonable level. And now we come to the main innovation in the ICC clause. And this option is to be considered very carefully. Parties will come, have give the power for the arbitrator to adapt, but will come with each of the party will come with a specific proposal, and it's give limits to the arbitrator within these two proposals to fix or to reduce the excessive onerosity or to adjust to a reasonable level. So this is also a way of being responsible as the parties of what you would like to hear from the arbitrator, of what you should, what should be done, not to be surprised by the position of the arbitrator. Why it is important? First, it is important because it gives limits to the arbitrator. Second, it is important because the parties are in the middle of the process of the adaptation. So they know exactly, and they will not go far in their proposition because the judge first will assess if it is in good faith or not. And in order to be in line what you would like to see, to presume the execution of the contract, you should really be adjusted. Now, I asked a friend of mine, I don't know if he's online, I won't cite him because it's Chatham House rules, what you expect, what you would have to ask an arbitrator if it has to adapt the contract. And it is in the energy supply sector, and this is the answer. As you note, that is very specific to this sector. If the arbitrator is not it does not know anything about energy supply sector, he will be into a mess. He would maybe not know how to deal with all these category of plus, all these details. So it's also the responsibility of the parties, again, to give proposal to someone who may understand what is about the situation in a specific supply, energy supply sector. So, and thank you, the unknown person, the unknown expert. Now, of course, the decision rendered by the arbitrator is binding to the parties in difference to the expert. It has limits also, for excess of authority in the place of arbitration or the place of enforcement. I take a previous example where the respondent party was not, did not accept the decision of the arbitrator, and the place of the court said, our power is not to see how the arbitrator adapted the contract, but if the arbitrator has the power to adapt the contract. So this is very clear. And the second, they assess the contract and they saw that the arbitrator follow what has been said in the contract, because the parties should try to reach a fair and equitable revision of the contract price. So the arbitrator follow the fair and equitable party to try to reach an agreement. And the court said to the party, you failed to you omitted in the contract provisions to give limitation to arbitrations when adapting the contract, and you did not give any structural limitation on permissible prices revisions. So again, we go back to what you have to do and what you have to put in the clause. Yes, and this is my conclusion.
Okay. Thank you very much. It was very interesting. I think that you know that in this city, people never go to have lunch before 2 o'clock. So I frankly don't think that we must be bound at any condition to respect the time of the end at 1 o'clock. I'm sorry, but I think that we must not penalize the last ones. And so I think, no, I wanted only to add, I think the important point is the general framework and the procedure of adaptation. If you can imagine the procedure for this, so how you fix a general framework, how you must make specific proposals, then you are able perhaps to put the question down to the practice and to make it more easy to find a solution. And then, of course, we all know that the last solution is that to say, okay, we must find an agreement because it's better that we find it than to give it to. But that is something that happens at the end when you see how things are going. So I now give the floor to Giacomo Rojas Elgueta, who is the last, and so that's always a bit, I'm very sorry for you, but I am even more sorry for Maria Beatrice, who will be the very last. So if you can be short, we are happier, but anyhow, you do what you do.
We are on time because
we
are on time. We are on time.
We are on time if we fix 2 o'clock for the end.
No, not 2 o'clock,
Yeah.
but...
Okay, go on. Sorry for...
Thank you very much. I would like to first thank the UNIDROIT and Professor Anna Veneziano, the ICC Italy, and Professor Barbara Donno, and of course Professor Bortolotti for the very kind invitation. If Jean-Paul Vuilletti and Emiliano Berti brought us to current and future times in a post-pandemic world, I have the duty to bring you back to a pre-pandemic and a pre-war time. So we are dealing again with old contracts, not with new contracts. So probably the title of my intervention should have been Not So Recent Events. As we have already said, when we discuss COVID-related events, we have to make a distinction between the disease, the illness, the contagion on the one hand, and the restrictive measures on the other hand. So according to Jean-Paul Vuilletti, it's always the second kind of events, type of events that is relevant for force majeure clauses. I would agree on 99.9% of cases. Maybe there is still a room for invoke the pandemic itself. We can imagine a factory that was providing essential services, so was not subject to restrictive measure, and half of the employees were sick and hospitalized, and maybe that would meet the threshold of a force majeure event. So this was the first clarification. So, of course, we have dealt with the elements of force majeure already, so I would briefly touch upon them just to relate them to COVID-19 in this context. So first, we know that the impediment must be beyond the control of the affected party. We can agree, I think, that the pandemic and the restrictive measures are beyond the control of private parties. And of course, if we are adopting the ICC new model clause, we know that this would be given for granted, being the pandemic or the restrictive measures already included in the list. Then again, we have discussed extensively about the unforeseeability element, and while the French courts have taken a very strict position as to previous viruses, so the dengue virus, the swine flu, always concluding they were obviously foreseeable, I think that for COVID-19, there are good arguments to say that because of the extent of the pandemic, it was not. And then, of course, the most relevant, in my opinion, element, the one where the dispute is really about, is the party not being reasonably able to avoid or overcome the consequences. This is, in my opinion, where the analysis from an arbitral tribunal gets to the very specific circumstances of the cases, where a party, of course, must show that it had no alternative means to perform, for example, getting the goods from another factory that was not closed, or shipping the goods to a port that was still open, or sending employees from a country where there were no travel bans. So this is, I think, the very core of the dispute where force majeure is involved. As to the burden of proof, of course, obviously this is on the affected party. One question is, what is the value of the so-called force majeure certificates? We all know that during the first months after the pandemic, many companies were rushing to the Chamber of Commerce to get this kind of certificates. In very simple terms, they only prove factual events, so they can certify that in a certain country there was, for example, a restrictive measure from a certain date with a certain scope, but they do not prove any legal issue, so they do not have any legal value. They cannot prove causation, for example, between the event and the non-performance of the obligation. I think this is pretty uncontroversial. Now, one of the, in my opinion, most interesting aspect of the litigation that arose after the pandemic is that in most cases, the issue was not really the fact of the party not being able to perform, which is what we have discussed so far, but the party not being able to use the counter performance. So if we look at the court's decision that have came out after COVID, most of them deal with the situation where a party could not, for example, board the plane and so enjoying the travel ticket, or use the commercial, use the space leased through a commercial lease contract, or not being able to use an hotel room that has been booked for a trip. So it is interesting how the force majeure or other doctrines from applicable law have been adapted to the non-use of a performance instead of the non-performance of the obligation. There is a very recent Supreme Court decision in Hungary where a company canceled 86 hotel rooms because the one tap of the Giro d'Italia should have been held in Hungary right after the COVID-19 outbreak. And it's an interesting case because the judges concluded that the clause, the force majeure clause, could have been applied, but they used an argument that is very close to the frustration of purpose doctrine in the UK, meaning that there was no Giro d'Italia going on, and so there was no meaning to use again the rules, but instead of relying on the presupposizione or frustration of purpose doctrine, the court applied the force majeure clause included in the contract. In Italy, there are plenty of court's decisions on commercial leases. The most adopted doctrine is this weird mix hybrid of partial temporary impossibility. So the courts, instead of saying that the lessee was not able to use the space that has been leased, is saying that the lessor was not able to perform. So he's departing from the idea that was affirmed before by Italian courts, where the not being in the position to use the object of the contract was actually the theory that was followed before. And I want just very briefly mention a very recent Court of Cassation decision by the French court, because at least in a survey that I have conducted with my co-author Benedetta Mauro, this is the only country where courts sided with the lessors and not with the lessee. So the Court of Cassation in France said that the force majeure could not have been applied, or the general principle of good faith, theory dell'imprevisione, etc. So it's a pretty interesting decision in favor of the lessor. So what is important here, and we have been talking about this all morning, is that behind all this there is a matter of risk allocation. And when we are applying a force majeure clause, we are allocating two different risks, and in a commercial lease it's very clear. So on the side of the lessee, you are bearing the risk of not using the counter performance, and so not being able to profit, for example, from the restaurant that you are renting out. But there is another risk of the other party, the lessor, which is called the price risk, is not receiving the rent. So if you apply force majeure, it's not necessarily an allocation of risk to one of the two parties, is in itself already a risk, a sharing risk technique, a risk sharing technique. Sorry, now, construction contracts have been mentioned before. It's another field where all these issues have been at the forefront. And the problem here was that most contracts do not include the hardship clause. So they do normally include a force majeure clause, but most of the issues were more related with hardship than with force majeure. And so we have to look at other clauses, changes of law, excuses for delays, etc. But I think is one of the laboratory where new clauses are now written and drafted. Now, moving to the second event that I would like to discuss with you, economic sanction. This has been also discussed this morning. So the starting point could be the EU Council regulation, which has been amended in March 2022, of course, to cope with the invasion of Ukraine, where there is a very straightforward provision, basically banning any transaction with a sanctioned entity. So this is the starting point. And here I think we do not, if there is a clear ban of this type, it's not really necessary to invoke the force majeure, because we could find in legal system other doctrines such as illegality, for example, that would already justify the non-performance. Then we have Another important provision, looking from the other side, saying that basically any claim that is brought by the sanctioned entity cannot be satisfied. So Emiliano Berti was touching upon this point before. Imagine Nokia being sued in Russia, and there is a claim brought by Russia. This article should provide protection to a EU company. Now, if we want to look at an economic sanction from the perspective of the force majeure framework, we can follow two different approaches. The first one, which I think is the most reasonable one, is to look at an economic sanction as a factual event. So the arbitral tribunal, the court, should establish whether the party was not in the position to perform because it could have been sanctioned because of that. But there is a second approach, which is called the legal norm approach, where a court or an arbitral tribunal would excuse the non-performing party only if the impediment is qualified as a sanction under the applicable law that is found through the normal application of conflict of law analysis. So we can either follow one of these two approaches. Now, once it is concluded that the sanction must be given effect in the dispute, it is obviously still necessary to verify whether the force majeure three requirements are met. And of course, here it becomes relevant to double check whether a license would be available as a way to circumvent the economic sanction. This would be the possibility to overcome and avoid the impediment. So very briefly, what are the remedies? Obviously, economic sanctions are normally temporary in nature, so the first answer is that the obligation, it is justified to suspend the obligation rather than immediately discharge the affected party. This is a conclusion that has been reached also under Article 79 of the CSG and under English law. But of course, the length of the economic sanction becomes relevant. So we have to look at the time when the sanction is lifted. And here we may have two different scenarios. The first scenario, the affected party's performance became meanwhile more onerous, and so this makes the performance radically, fundamentally different from what had been originally undertaken, or the counterpart is no longer interested in receiving the performance because of the passing of time. So if we are not applying the 120 days default provision of the ACC clause, we have to understand whether the time that has passed is enough to justify the termination of the contract, not only the suspension of the performance. And this is a result that may be reached also not only through FM clause, but also through the application of the governing laws of the contract. So we have frustration, impossibility, commercial impracticability, etc. Now, in another scenario, and is the one where the economic sanction does not directly affect the performing party, but a party has to withhold its performance because the suppliers is defaulting because of a sanction. So we have heard a lot about the procurement risk today, which of course lies with the seller. So does it mean that is this the end of the story? I think no. There are possible remedies. Of course, it depends on the language of the clause or the applicable law. But for example, under English law, it may be relevant to look at whether the contract specifies that the seller should have found the goods exactly from that very supplier, which would make the unavailability of that particular source relevant. Or if you look at the comment comment included in the official comment of the Uniform Commercial Code, you can read that there is the possibility to invoke commercial impracticability exactly in this scenario when a severe shortage of supply is due because of an embargo, and the embargo is at the origin of the increase in cost or the prevention of the seller to secure the supply. Of course, we can also look at excessive onerous or hardship as other remedies. Last slide, last point. Related with economic sanction is, we have, I think, heard a little bit about this also before. We have many companies that are withdrawing from Russia, more for reputational or geopolitical, let's say, consideration. And of course, they expect to be sued by Russia because they are unilaterally and abruptly, if you want, terminating the contract. So now the question is whether what are the possible remedies in this context, and whether in particular force majeure would be a viable defense. I think it would be very hard to invoke force majeure in this kind of scenarios because, of course, the war is not happening in Russia, it's happening in another country, and so it would be a difficult argument to make, but I think that if we go back to Article 11 of the EU regulation and we read that also the indirect effect of economic sanction is relevant to paralyze the counterclaims, there is still a room to build some defenses in this kind of scenario. And this was my very last point. Thank you.
Thank you very much. Before giving the floor to, I think we skip the questions. I think it's too late, no? Or do you want? I don't know. Do you agree that we skip questions and answers? They are online. Online, no. Here, our... If you are very quick, yes. Sorry, we don't hear you. Push the button.
I have a short question concerning more or less whether I understood you correctly. You quoted Article 11 of the European regulation. Does this regulation also cover execution of a foreign arbitral award? Let's take the example of a litigation which takes place in Switzerland, in Geneva. And in Geneva, they don't apply Article 11 of the EU regulation. And then they render an award. Would such an award be enforceable in the EU?
My first reaction would be yes, in case the party that is sued is included in the scope of the EU regulations. So whether it is a EU company, which is the one receiving the claim or receiving the final arbitral award. So my understanding about I didn't give to this point further thoughts, but my understanding is that the scope is very broad, and so this should be the result. So to be able also to paralyze the enforcement, basically, of a court opinion or of an arbitral award.
Okay, thank you very much. I have I received the present. I want to share with you this book that she organized. She didn't draft it. It's a lot of articles. It's a collection of arbiters with the title Balancing the Protection of Foreign Investors and States, Responses in the Post-Pandemic World. Very interesting. If somebody wants, it's published by Klüver. And now we are coming to the end of the story. And I will ask Maria Beatrice if she can give us an idea about a conclusion. It's very difficult. Però avevi paura che fosse difficile, ma tu sei bravissima. I am sure she will make a very nice and interesting conclusion. And so then we can go to have some food, because it's time. For us, it's 1 o'clock. For them here, it's 2 o'clock, 3 o'clock, but we are different. Please.
Thank you so much. It's a very difficult task. I am at the same time honored by the invitation of Fabio and Barbara, but of course worried. Thank you. So we are running out of time, and therefore I will be even shorter than I was supposed to be with closing remarks. And so let me start saying that my closing remarks will necessarily be composed of thanks, congratulations, and little merits, because much has already been said, and I will only try to highlight few of the many concepts expressed today by the speakers. So, first of all, thanks and congratulations to Fabio, the mastermind, as Anna called him. The mastermind, we invested so much in the CLP Commission for many years, and eventually in 2020, he reached the goal to elaborate the last version of the Force Majeure clause just before two major events would, by themselves, raise the issues of enforceability, resistibility, and avoidability. And so we saw in the debate how difficult it is to define the content of what is foreseeable and what is not. So Fabio's presentation today recalls the conclusions we have all learned in his dense article on arbitration practice regarding the force majeure claims. And in the end, although he could ascertain a certain uniformity in the practice, nevertheless, we know that arbitrators may decide independently without taking into account the value of precedents. And so I took his comments at the end of the article and also today as a warning to all of us who act as arbitrators. Thanks and congratulations to Professor Donno, who took over the lead of one of the most important commissions in the ICC world. When we met this morning, our simultaneous greetings was, finally we did it. Here is the Force Majeure conference we've been working on for months before I stepped down my role as Secretary General of ICC Italy. And thanks to the presentation of Cument, we had a full reconstruction of the process that brought the working group chaired by Fabio to the new ICC clauses. And his rich description clearly illustrated the reasons of a limited but still significant reform. And the audience could also have a touch, I believe, of what kind of work is done under the aegis of the ICC and the ICC commissions. So I can simply add that Professor Bortolotti should be very happy and proud, for Professor Erdem is an excellent successor in chairing the CLP Commission. Thanks then to our host, Anna Veneziano, Deputy Secretary General of UNIDROIT, who so genuinely always promotes the UNIDROIT principles, which in a way inspired the ICC clause. They are versatile tools for a versatile instrument, as the force majeure is supposed to be. And then after the first three contributions, who really set the scene, Jean-Paul Veuilletti and Emiliano Berti were called more or less as witnesses to bring their experience as lawyers and corporate representatives. And what we heard from them was very interesting and also quite provocative, I believe. In their opinion, and of course I'm summarizing, so many things have been said. Probably the force majeure clause was not tailored for the present situation, and in any case, force majeure
and hardship clauses cannot be the sole clauses to rely on. And Jean-Paul Vieilletti invited us to consider what I thought was very evocative notion of disruption bubble. So a more comprehensive concept, which is partly superseding the two different notions of force majeure clause and hardship. And of course, the essential expression that I try to quote is the allocation of the risk disruption. Then in the words of Emiliano Berti, we had important comments on the perception of sanctions in under the different perspective, the perspective of Western countries and Russian parties, which could make unfeasible the concept itself of force majeure and hardship. And in relation to the strong and devastating effects of the last 2-year crisis, the increasing prices of raw materials and oil and gas made necessary to consider the impossibility to perform. And then we had the voice of business, and we had a panel which was fully composed by in-house. It's an inestimable richness in every conference organized by ICC when we are dealing with international commercial law. So we had Annie Plenitude and Enel, so Marina Mercante, Edoardo Marcenaro, coordinated by Gabriella Porcelli. And so they really witnessed on what has happened in the past and present months, especially in the contractual relationships with parties affected by pandemic, war, and sanctions. They also described which measures have been adopted by their companies to cope with these problems. And so together with Gabriella, who moderated the panel, I think they all noted the difficulties in interpreting the notions of force majeure and hardship and the need to apply them to the case at stake. And of course, what I thought was extremely important also for the work of ICC is to keep an eye on micro, small, and medium enterprises, especially the micro and small enterprises, which need to be supported probably more than the big players in the field. Then the last contributions by Pascale Caruy-Lofin and Giacomo Roca Salgheta offered us an essential perspective of other two major issues. Pascale offered a complete overview of the hardship clause, and she analyzed the clause also evidencing the need to share this new concept of flexibility of the contract in relation especially to the renegotiation of the contracts. And also, I found it also a bit provocative, the focus on the appointment of the right arbitrator. It's probably a sense of guilty that should fit the case, also considering the methodology to be used in relation to each case. And I must say that her indication as to the required characteristics of the prospective arbitrator sounds very challenging, not impossible, but challenging. Then with Professor Giacomo Roca Salgheta, we moved even closer in considering the effects of the two major events we experienced soon after the ICC clauses were finalized, pandemic and sanctions. And some of you might recall the very first online webinar organized by ICC Italy soon after the outbreak of the pandemic. It was probably the first or the second webinar we organized together with Professor Bortolotti, where Giacomo participated as speaker. So it's quite a while that is working on the matter of the effects of the pandemic. And I can say that although he was the last speaker and had to speed up his contribution, he clearly and fully reconstructed the situation created by COVID. But his contribution was improved with the addition of important considerations concerning the effects of sanctions against Russia, discussing possibility that sanctions are considered or not a force majeure event in the presence or not of a license, and then also illustrating the different scenarios presented as possible remedies offered to the parties to contracts affected by sanctions. So before closing, I also wish to thank my colleague and friend Barbara De Donno, who so brilliantly conducted the organization of the conference, having took the reins of the Italian National Committee of ICC, which is something I'm very much grateful of. And then just to conclude, and I hope, well, almost ready, thanks again to all the contributors for this conference, which allowed us to make the state of the art on the 2020 Force Majeure and Hardship clauses, with the hope that the events that in the last 2 years made these clauses so crucial will soon be overcome. Thank you.
So now my task is to close the meeting, to thank everybody. I continue to thank as you did before, no? So the UNIDROIT that is hosting us and also participating to the, of course, ICC Italy and ICC in general, our argument as the chair of the CLP Commission, and all the people who have come, and all those who have been who have come to Rome and who were willing to speak here. I think it's really, and particularly I want to thank the in-house lawyers who we wanted to have a meeting where we would speak about the real problems and not about fried air, as we say, aria fritta in Italian. And I think that also thanks to them, we have been able to do this because they bring us down to reality. And I think that's the real problem, because we can, if we have to deal with force majeure, hardship, and so, we must look at the problems from a practical point of view. And from this point of view, I think, you know, so I conclude that it is very interesting what I discovered looking at the arbitral case law, how arbitrators tend to have a common view on these things, because I say arbitrators who are practical and who are competent and who have good experience, but they are the majority, and they are able to understand that the problems are always the same, whatever the rules, the laws, and so. And this is, I think, very important. It's a reason also to appreciate the possibility of solving these problems in arbitration. I think arbitration is the best solution if there are big problem of this type, because you can find people who really understand what it is about. And this is, I think, really important. Thank you very much, everybody. I am happy.
Thank you, everyone. Just remember that on Monday there will be an online cafe for in-house counsel with Claudia Salomon, who chairs the ICC International Court of Arbitration. So thank you, everyone.